No, I beg to mention, listing, placing of the written argument, which is fixed for tomorrow,
This,
Maybe I'll place-
tomorrow, কাইলে কাৰণে এটা spoken to এটা কি কয় delivery of orders আছে না সেইটো.
May I please your lordship?
Yes,
I beg to mention item number 43. 43.
43.
43. Service on by respondent number 2 further awaits.
It has been, Mr. Spencer appears for the petitioner. Service report on the respondent number 2 is awaited. List this matter again after 2 weeks on a date to be fixed by the registry along with this service report.
Lordship, may kindly fix it after vacation with a fixed date.
2 weeks.
2 weeks.
We have 1 week to go. It'll come after vacation.
Oblige.
Please,
Yes,
I beg to mention item number 42.
42. Yes,
The matter may come up after vacation, my lord.
at the request of the learned counsel appearing for the petitioner, let this matter be listed after 2 weeks on a date to be fixed by the registry.
Please,
Yes, sir.
Item number 40, your lordship may not like to take up this matter. That Rabul Huda matter.
List this matter before any other bench without me.
May I please your lordship, in
Yes.
item number 10, my lord, I filed an additional affidavit before yesterday, man.
You want it called? Yes.
May I please your lordship, I beg to mention item number 33, lordship. The case diary has not been received. I think last 5 occasions, the case diary was not there, though I'm on interim. Can it be on 18th, lordship? 18th?
Most urgent,
At the request of the learned APP to procure the updated case diary, list this matter again on the 18th of December 2025.
The interim,
Interim order passed earlier shall continue.
DP of like.
Oh, one thing, you are allowed to go before the IO and if on arrest, you will be released on bail. That is the interim.
Lordship,
Why does it need to continue if he goes and appears and then he's released on bail?
I appeared also.
Okay. Huh? You are already on bail.
Lordship,
Yes.
May I please your lordship, I beg to mention item number 17 and 18. In item number 18, we need some more time to file our reply.
I'm for the petition, I don't know.
At the request of the learned standing council, CBI, to which the learned council for the petition does not object, list this matter again after,
A week.
again after a week on a date to be fixed by the registry.
Oh, week, but next week is motion. Maybe in January. The date
After a week. So it'll come up in January. Okay, after 2 weeks.
The date may be fixed.
January, we are not fixing dates. Everybody has clogged up the registry,
And
fixing dates. Huh? Oh, you are appearing for the petitioner. There was a request for VC.
yes, I'm sorry.
You are withdrawing it. That request to withdraw by the.
I'll write a formal email. I was not supposed to be here today.
All right, no issues.
May I
Yes.
please, your lordship, I beg to mention for an requisition in item number 29.
Requisition?
Yes, your lordship. I have filed an additional affidavit day before yesterday.
Okay.
Very important facts are to be brought before this.
You want the affidavit to be called? for-
Tag,
Okay.
29, item number.
Rashid, let his affidavit come and do it.
Of like,
Yes.
Motion on here, item 1.
May I please your lordship? My lord, application under section number 483 BMS
Hmm.
for regular bail, my lord. This is my lord, case of my lord NDPS intermediate quantity. And heroin of 14.83 grams recovered from this petitioner and another lady who were traveling in a scooty. And my lord, they are in 41 days in the custody, my lord. On the 2 counts, I am before your lordship, my lord. One is the length of detention, my lord.
Hmm.
And the other is, my lord, that 48 DNSS,
Ah,
that a notice has to be, my lord, given to the, my lord, to the friends or his relative,
Ah.
or any, my lord, authorized person, my lord.
ah.
That has not been complied with.
It has not been complied with
That
at
has
all.
not been complied with.
Yes, sir.
Mainly, my lord, I am on, my lord, length of detention, my lord. And I have got a, my lord, decision of this honorable court, my lord, where without calling for the case diary, my lord, on the very first day, my lord, bail was granted.
No,
They-
for
A little
verifying,
difficult,
verifying that
little
Malat
difficult.
48 was really Malat Sabor not Malat that
Huh?
whether for Malat 48 notice was Sabor not Malat.
Hmm.
To verify that Malat CD is recorded. Otherwise Malat
Records indicate that the notices required under section 48 were duly served, is what the
48
earlier
days.
order has recorded.
Yes, my lord, but in the, my lord,
That-
trial judge, my lord, on the, on 27/11 order, my lord. We have raised this point before the trial court also, my lord.
Hmm.
And that record was, my lord, not looked into, but as my earlier application was rejected, my lord. For that reason only, my lord, my subsequent bail petition was rejected.
Problem is,
Why-
if once a judge records that 48 is served, unless it is shown to be totally absent, the lower court, the trial court would not.
That has to be seen from the, my lord, the GD diary, my lord. GD book, my lord, which is available in the police station.
yeah,
That is the-
along with the Malat case it will be there Malat 48 notice.
Yes,
Mainly, my
37
lord, on
days, people have been granted bail. What do you say?
Mainly on the period of
41 days.
detention, I am before your lordship, my lord. I will face the trial, I am a lady, my lord, I have got a.
Had it been Malat any public vehicle or all this, Malat scooty Malat means
Maybe for
He
He
her,
was driving it or she was the pillion rider?
both of them were, my lord, there. She was driving, my.
She was driving, it is her scooty. I mean, here Rajeshwar we have. This 48, when can you have the information?
48 Malat short date can be given Malat on Tuesday Malat 16.
16, sir?
Avlaj.
16th, 16th will, if 48, we do not find anything. We consider the length also on that day.
My lord.
At the, heard Mr. B. M. Chaudhary, counsel appearing for the petitioner, also heard Learned APP. Mr. Chaudhary has submitted that the petitioner has already spent
41 days.
41 days in custody. The grounds for bail is the length of detention and also that the notice under section 48 of the BNSS was not served. Full stop, the learned APP seeks an accommodation to verify the service of the notice under section 48 of the BNSS. List this matter again on Tuesday,
16th.
16th of.
I am obliged.
Yes, sir.
May I please, this is commercial quantity, madam. TCR may be called from, madam.
Mr. N. Mahajan. Application for bail under section 483, page 1, you take the concerned case. Mr. APP, so and so, call for the trial court records list on.
After vacation, only 5,686 gram of yaba
Only,
only.
January,
Then
January, hey, did you? Buy some? A list after the behaviors on a date to be fixed by the registry.
Be a date, my lord, because
We are not giving a date because there's a request.
let it be after
It's-
this vacation, my lord.
It's
not-
clogging up. After this vacation, we'll have only 1 week. All the matters of these 2 weeks
That is the.
will
Let
clog
be
it up again. Okay, after a list after the winter vacations. On a date to be fixed by the registry. Winter vacation.
Special Judge Sri Bhumi, madam.
Oh.
The TCR, madam.
From the
For
court of
this
special-
can copy of the TCR from,
the court of special
Special
judge,
Judge Sri Bhumi. madam.
Tribhumi.
okay?
Special customer.
I have underlined it in page number 1.
Madam. That's will highly eligible.
Mate, please, your
Yes,
lordship, 483 matter, charge sheeted matter, your lordship, 21B along with 27A, your lordship. However, your lordship, when we, on the perusal of the charge sheet and the document submitted, nothing with regards to 27A.
Hmm.
Charge sheet was filed on the 67th day and now it is 141 days behind the bar, sir.
and how much was recovered?
It was recovered as 13 containers, including 14 grams, but after the FSL report, which is here, it is around 2.69 grams, sir. around 2.69. 2.56 grams. But
Yes,
recovery
sir.
was of 19 grams,
No, recovery was 19 gram, yes.
including the vials, and FSL report is your worship at page number 21. Your worship. Description of the articles, and here the calculation accumulates to 2.56 grams. Already
2.56.
No, these are
This is not sampling, total.
marked as S1 to S13. Ah, yes.
Total 2 point some grams. And
141 days.
141 days. Huh?
Blank.
Moreover, your lordship, in the chart sheet also, in point number 20, they have enclosed 4 documents, but nothing with regards to
27A is not there.
bank transaction, monetary transaction, money, nothing, your lordship.
Any money recovered or any bank
Money
accounts,
is not
nothing.
recovered. Money, I have checked.
27A goes and 2.4 grams is something perhaps you can consider. $35. Yes, heard Mr. So-and-so. Also heard the learned APP. The learned counsel for the petitioner has, this is a bail application under 483 for the petitioner in Doboga PS case number so-and-so, in which the charge sheet has been submitted and the case is now registered as NDPS case number 69/2025. Pending trial before the court of the special judge Hojai. The learned counsel for the petitioner has submitted that the total quantity of alleged recovery of heroin is 2.4 grams.
2.56 grams.
2.56 grams and that no recovery of any material to indicate any profit of business of the same has been alleged. Full stop. He has therefore prayed that the case of the petitioner be considered for grant of bail. Learned APP has objected to the same, stating that at this stage there may be an apprehension of influencing the witnesses. Full stop. Having considered the submissions made and the materials available on record, this court deems it fit to grant the privilege of bail to the petitioner who has completed 141 days. 141 days. Full stop. Accordingly, directed to be released on bail on submitting a bail bond of rupees 20,000 with 2 sureties of the like amount to the satisfaction of the
Special
learned
judge.
trial court. The following conditions also, huh? NDPS ka conditions lagwa dijiye.
Deeply alleged.
Is disposed of. Mr. Parashar, there is a notification which says that now there has to be a declaration that no other, he is not involved in any other criminal case and also that no other bail petition is pending.
No other bail petition pending is
He is not involved in any other case is necessary because we need to know whether he is
antecedent.
involved in anything else or not. So kindly when you go through the bail petitions
Well,
or the anticipated bail petition, find out whether that paragraph has been included. I think day before yesterday, the notification has come from the High Court. Earlier, it was just a direction from the Supreme Court. So keep a track of that. Unless that statement is there. we'll
no
have it.
bail petition pending, that is giving, but regarding no other case is pending.
No other, we are not involved in any other criminal cases, what is perhaps now required. Today, this week, we are not taking that issue
Well-
up. Next week on whatever comes up, just have a,
Well,
yes, sir.
My lord, I'm on, my lord, regarding not on Barrett Mural, I'm on whether I'm entitled for a default bail or not. That is the issue here before your lordship to decide. Now, I was arrested on 3 August 2025.
Hmm.
And my lord, my statutory period over at 31/11/2025.
Hmm.
I filed my bail petitions on 1st of November, my lord,
Hmm.
1/11, at 10:30, my lord.
Hmm.
And search sheet filed at around, as per the court record, it said that search sheet filed at 11 o'clock.
Hmm.
Now, whether, my lord, I'm entitled for a default bill or not, that has to be
On the last day,
my lord.
you moved an application on the last day, on the last day the
No,
charge sheet
not
is.
last day was the 31st,
Huh,
90 days expired on 31st.
31st, yes.
Then first I filed at 10:30.
Ah.
Your lordship will kindly look at my applications, my lord. I'm not on the FIR, my lord. Kindly see.
Page 35.
My lord will find. 31, my lord. Your lordship may kindly see the 31, my lord.
Hmm.
This is my applications, my lord, that the charge sheet of the extent case was not put before the Lanet court till 31/10/2000 within a stated period of limitation, and accused was produced before the Lanet court after being arrested on 3/8/2025. That since the accused completed the statutory period of limitations on one's own bail petition was filed to move at about 10:30 a.m. And at that relevant point of time, the charge sheet was not produced before the Lanet court. In the relevant time, charge sheet was not produced before the Lanet court in connection with the case. As such, the engaged counsel were inside the Lanet court since 2 p.m. my lord. Generally, what has happened in the court below, when you file, my lord, that matter always taken at 2 o'clock, my lord, to move the bail petition. In the meantime, some of the police division came with the CS, my lord, of the case along with the relevant document to place before the Lanet court, and thereafter the police officers started arranging the documents of the case diary in proper way and a flag mark, and continued up to 4:30 p.m. inside the courtroom. Although the Lanet court was not in session, and thereafter they called another police officer, more particularly female police officer, inside the courtroom and alter the date. Well, I can show, my lord, from the charge sheet, I have the charge sheet, my lord, I can show, my lord, your lordship will kindly see that what my allegation is concerned. I'll just finish it off there. Send from the court, although case record is renumbered as so and so, so and so, so and so, my lord. This is my applications, and your lordship will find the session court orders. That is a session court order, while rejecting my bail petition, discuss that why I'm not entitled for a default bail, my lord. Kindly see, and I'm very sorry to say, the session says he has Mohanlal Aria's case has been referred, my lord, that 2001-5 SCC, my lord. This case has been referred, my lord. And what paragraph 9, your lordship, kindly see, that is at page 38, my lord. I'm very sorry to say that Lanet session judge, how he has dealt with the matters, he said, kindly see, moreover, the present petition, kindly see, before the court, this court is what again on 480. Well, it has to be 480, my lord, but not under 187. 187 regarding the time period which has been 167, 2 has been 167, is now 180, my lord. Now, what he says that I have to file a bail application, is it, my lord, the way the session judge has dealt with, my lord? Now I'll show the charge sheet, my lord. And that is also part charge sheet, my lord. It's not a complete charge sheet. Kindly show, my lord.
Mr. Parashar, kindly have paragraph 7 at page 38. The right of default bail was not availed of in the manner contemplated in law. Once the charge sheet was received, that right stood extinguished. Can it?
My lord, I have also one calculated, my lord may see. On that day, it's only 90 days, not 91 days, on the 1st of November. My lord may see my calculation, my lord. Kindly.
We'll see the charge sheet.
I'll show, my lord. He has calculated 31st day. It's not 31st. 30 days, 30 days, 30 days. Kindly see, I'll show the charge sheet, my lord. The lordship will kindly, I'll just mark this one and I'll show.
Forwarded on 3/8. Forwarded
Yes.
on 3/8, so
3/8, my lord.
August will be 28 days. August 28, November 30,
90 days.
90 days offense.
90
August
days
will be
from
3/8. August, forwarded on 3/8. So in August is 28 days, September is 30 days, and October is 31 days. So total come,
1st of November is the 90th day.
yes, 1st of
Well,
November is the 90th.
It will be because your lordship has to take into account of 3 also. If you take 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29.
First day is the third.
30.
My lord, my limited knowledge, my lord. We have,
First day you have to keep, my lord,
My lord,
because you have to produce on
yes,
third.
yes, my lord.
Third will be there, my lord.
My lord,
Kindly see the search sheet, my lord.
my lord,
It's a
the
part search sheet, my lord.
language, my lord.
Now,
what is-
I'll show.
Just, we just
Just-
wanted
just-
that
just-
calculation.
yeah.
I think, yes.
I'll show, kindly see the, I have just tick mark this one. Kindly see, this is not a part search sheet, my lord. It's not a final reports, my lord. What it says, that there are so and so are to be, and I'll produce forthwith, are to be collected. That meaning thereby what? That the investigation has not been completed, my lord. So that is number one, my lord.
Hmm.
And number two, regarding, my lord, kindly see next page, turn the next page. I round off, my lord. Kindly see the date. 31 and 1.
Yes.
So you cannot do this type, which, where my personal liberty is at stake, my lord. How you can do, kindly see 31, then again 1. This is a search sheet has been provided to me, my lord.
Mr.
This
Parasha,
is
this
not
overwriting
completed.
is something which is touching us.
Yes,
Your calculations and all we will see.
My lord, whenever court asks the how many days you are behind the bar, I am behind the bar since last.
Hmm.
If arrest
We are- no, no,
yesterday, then
90
it's
days, 90 days we will look into it.
Yes,
90
but
days we will
regarding
look
the,
into it. If there is an overwriting on that day, when this was being placed before the learned trial court, at least the persons placing it before the learned trial court were under an impression that the last date will be 31/10/2025. Therefore, the overwriting from 1/11/2025 to 31/10/2025. They attempted to show that we have submitted the charge sheet on the 90th day. That was the attempt. Now, this is the investigating authority or the PI court. Someone from there has done it. And the court has refused to look into it. This is an attempt to keep the person behind bars without arguing on the merit of the bail petition. He argues on a technicality, they are trying to change the technicality.
technical.
Had he argued that it is second day of November, they would have said, yes, we have submitted on 1st of November. If he says it is 31st of October, he will say, I have submitted on 31st of October.
My lord, my lord, there's two judgments I have referred to. One is by regarding the part search sheet,
Huh.
keeping me behind the bar. And one is, my lord, regarding 187, that Ravindran judgment, my lord, 3-bench judgment.
What does that part charge sheet say?
Part search, you cannot put it like this, part search sheet. That is a established law which has been, my lord,
Court highlighted the Supreme Court's ruling, which clarified that part charge sheet does not extinguish the right of default bail.
Yes, yes, that is.
Now, when here you may go through it for your
Well, there-
convenience. It is to be mentioned that few additional evidences and reports are to be collected. So it becomes a part charge sheet and awaited in the interest of the case, which will be submitted forthwith to the honorable court. And this has been done. After this was done, when they realized that the date will now be a problem. The attempt, may be very honest, we should not let the man go out right now, there will be a difficulty in investigation, but that could have been simply placed before the court that yes, we need to collect more evidence. Don't release him now, default bail is okay. Put up the stringence of the conditions, but trying to manipulate the date.
Collecting documents, my lord, it's, my lord, in some cases, if you treat, in
All-
case of POXO, if statement of the girl is there, others is there, maybe official not there, in that case, my lord, yes, even if, with the statement of the girl, can be. But if here, my lord,
They are saying that we have to
some documents has to be. put.
additional evidences and reports. So how come a charge sheet?
Maybe.
So
official.
even if we ignore the manipulation of the date, he would still be entitled to the default bail. Since it's a part charge sheet.
Yes, part
Charge
charge
sheet.
sheet, my lord, I can.
So on that ground, perhaps we need
Madam,
not go and look into
that-
the
that-
other part.
that-
But we are going to observe in the order that this sort of a manipulation by the
Yes,
PI
my lord,
and
my
the
lord, my lord,
official
my lord,
involved
yes.
we will call for an inquiry through the department as to why this was done.
Yes,
Honesty is, integrity is something we expect of the executive,
definitely. my
as
lord.
it is expected of us,
Yes, yes, my lord, definitely.
is it not? This will not be, this will
Yes,
not be the issue. Have a big fight. Take it up to the Supreme Court. But manipulating it at the base level,
my lord.
this has to be curbed at at the bud, nipped at the bud. What is it?
My
Nipped
lord,
at
I
the bud.
mentioned in the
Yes.
order, my lord, I'll also communicate from my end.
This has to be taken up seriously. This sort of, but if the police start doing this, the line which was very thin will become thinner for us to believe any of the. Yes. Heard, the senior counsel appearing for the petitioner also heard. Heard Mr. P. Bharat, senior counsel appearing for the petitioner assisted by K. Sharma. Also heard Mr. K. K. Parashar, learned. APP, full stop. This is a bail petition filed under Section 483 of the BNSS 2023 with regard to Borborua PS case number 64 of 2025. You take it from page 1, huh? The learned senior counsel for the petitioner has submitted that an FIR was lodged on 27/7/2025. by one, regarding the death of the uncle of the informant, comma, which was suspected to be an unnatural death involving burglary. Full stop. Pursuant to the investigation conducted, comma, the investigating authorities had arrested the petitioners herein on
P8, Miller.
P8/2025. The petitioner herein on 3/8/2025, full stop. The learned senior counsel for the petitioner has submitted that on 1/11/2025, a petition was moved before the learned additional chief judicial magistrate Dibrugarh, praying for bail of the petitioner. This 29 was after 31. 31 is the application and 29 is the order.
Mine. 20, no,
31 is the application moved or it was moved after the order?
no, after the order, before the learned session, judge. Why it has been rejected, Miller?
No,
Well-
what we are asking is this, sir. Page 29 is an order of the court.
Order-
Additional chief judicial
order of the
magistrate.
CJM
Order of the
Right?
CJM.
Then page 31
is
is
the application before
an
session. judge.
application before the additional CJM.
CJM.
What we are asking is this application came first or the order came first?
No, this, my lord,
Because maybe after the bail stood rejected,
my lord.
thereafter this application
Yes,
was
yes,
moved,
It is fine, it is fine. It is fine.
which was rejected by an order of 1/11/2025 itself. When the said order, after the said order was passed, comma, the petitioner moved another petition on the same day before the learned additional CJM seeking to bring on record the manipulation in the date recorded in submission of the case diary. Stop. When the said application was not attended to, just a minute. That is the correct part.
This entire thing has been reflected in the order of the session judge, Miller.
No, we can't write it wrong in the order. It is fully cooperating. Dispatch has been granted, it rejected. That is annexure 4. That being aggrieved. That being aggrieved, you filed a bail petition. You have given the wrong annexure. Annexure 32. You should have put the application before the sessions judge.
No, I have, but.
They
because
have
I have-
annexed the,
That was annexed, Miller. That was annexed, Miller. Your lordship kindly see that I have not annexed. I got this thing later on, Miller. I got it before the.
in our record, page
Final.
32 is the application to the additional chief
CJM.
judicial magistrate.
Fine.
That is annexure 5.
I,
And annexure 5, when you refer to the paragraph, when you refer to the paragraph, it starts with approach the learned sessions court Dibrugarh.
no, Miller.
Has to be.
No, that, my lord, it was an annexure to the session court, Miller.
This application.
Yes, annexure to the session court.
This is an annexure to the application file. Now,
File.
this is actually the application file before the additional CGM,
CGM and.
which was annexed to the,
Annexed to the.
okay,
File
then you correct it up. What did you say? What did I say? No, you cut out that part. You go to that part. That's the learned ACGM rejected the bail petition, है ना? Strike out whatever was underneath. Okay? Aggrieved by the said rejection, comma, the learned, the petitioner had approached the court of the learned additional district and session judge at Dibrugarh by filing a petition on 10/11/2025 and by the order dated 12/11/2025, the learned session judge has recorded that the charge sheet pertaining to Borbarua PS case number 64 of 2025 was duly received at the GR branch on 1/11/2025 at around 11 AM and was placed before the court of the learned additional chief judicial magistrate on the same day. The learned sessions the learned court of the additional session judge was therefore of the view that the charge sheet was received and taken on record on 1/1/2025. Full stop. The learned counsel, the learned senior counsel appearing for the petitioner has drawn our attention to the copy of the charge sheet submitted before the court of before the additional CGM, wherein he has pointed out that the prosecuting inspector of the Dibrugarh court has overwritten the date of 1/11/2025 as 31/10/2025, full stop. The learned senior counsel has submitted that this manipulation was done since the ground, this manipulation was done only to resist the assertion of the petitioner that 90 days had elapsed as on 31/10/2025 and he was entitled for default bail as on 1/11/2025. The learned senior counsel has submitted that such manipulation at the hands of the prosecuting authority cannot be tolerated. And in view of the unlawful attempt to manipulate dates by the prosecuting agency, it would be apparent that all attempts are made to detain the petitioner in custody. Full stop. He has further submitted that a perusal of the charge sheet itself would show that that it mentions that, you'll now put it under the inverted commas, that a few additional evidences and reports are to be collected and awaited in the interest of the case, which shall be submitted forthwith to the honorable court. Full stop. The learned senior counsel submits that a reading of the aforesaid would reveal that this was only a part charge sheet and not a charge sheet as required in law, and therefore, even if the same is taken into account, in view of the judgment of this court in Samirul Ali versus State of Assam, reported in 2023 4 GLT 1175, a part charge sheet does not extinguish the right to default bail if the investigation is incomplete. Full stop. He therefore prays that in any view of the matter, the petitioner would be entitled to the privilege of default bail in this case. Full stop. The learned APP
My lord,
has,
only one thing, if my lord, on 1st of November, it is, as per my calculation, it is 90 days. If, yes, at all, a
We will
petition is,
dispute it.
petition is filed before the charge sheet, then they are entitled for default bail. And now.
if it is a
only-
part
only-
charge,
only
if
because
it
of
is a
this-
part charge sheet, we will only grant him bail because it is a part charge sheet.
And
We will
only
keep
the
that
over-
other question open to be decided in an appropriate case.
And my lord may emphasize on the overwriting, but otherwise, my lord.
Yes, yes, we'll do that. We'll do that. Listen to us. Learned APP, Mr. KK Parashar has submitted that the 90 days time would expire only on the 1st of November 2025. And even if it is assumed that the charge sheet was filed on 1st of November 2025, there is no delay. And then the same does not cross the bar of 90 days, and therefore the petitioner would not be entitled to the benefit of default bail on that ground alone. Full stop. The learned counsel for the petitioner has, learned APP has further submitted that what is your other submission?
My lord,
Therefore, the learned APP therefore submits that since the petitioner has not been found to be entitled to the grant of default bail, the present petition may be dismissed. Full stop. The submissions made by both the counsels appearing for the parties have been considered. Full stop. The question as to whether the petitioner would be entitled for default bail in case it was submitted on 1/11/2025, considering his date of arrest to be 3/8/2025, is not being gone into at the present, since it is apparent that the charge sheet submitted is itself a part charge sheet and the date of submission, whether taken to be 31/10 or 1/11, would have no relevance presently in view of the judgment in Samirul Ali within brackets Supra, which provides that submission of the part charge sheet would not interfere with the right of default bail. Full stop. A perusal of the charge sheet shows that the investigation is yet to be completed, since it is an admitted position that few additional evidences and reports were yet to be collected and awaited. Full stop. Therefore, in view of the fact that only a part charge sheet was submitted either on 1/11/2025 or 31/10/25, comma, in both the cases, the petitioner would be entitled to the privilege of default bail. Full stop. Accordingly, that part, the condition part will put on later. Go to the next paragraph. This court is not happy with the manner in which the date with reference to the submission of the charge sheet has been attempted to be manipulated by the prosecuting inspector of the Dibrugarh court. Full stop. It is apparent that manipulations have taken place where the date has been brought back from 1st of November 2025 to 31/10/2025, and this has happened apparently after the petitioner had filed the bail petition. Full stop. Even if it is assumed that the charge sheet was filed prior to the petitioner having preferred the bail petition, comma, it cannot be taken lightly that the prosecuting inspector had attempted to manipulate the date of filing of the charge sheet to 31/10/2025. Full stop. This reflects on the integrity of the person who had attempted to make the manipulations in a charge sheet, comma, which is a matter of record of the court. Full stop. We are also surprised that the learned additional session judge did not notice such a manipulation. Full stop. In view of the above, this court directs who is the disciplinary authority of this person? The SP, comma, Dibrugarh, the Superintendent of Police, Dibrugarh, to immediately call for certified copies of the charge sheet submitted before the court, before the trial court, and cause an enquiry as to whether such manipulations had in fact taken place, and if such manipulations were effected in records which had been submitted to the court, comma, appropriate action be initiated to ensure that such appropriate action be initiated and brought to their logical end within a period of 2 months from the date of this order. Full stop. Although this bail petition is being disposed of, however, the same be listed again on the 1st of March 2026.
Maybe Richard, my lord,
Huh?
although bail petition is allowed, my lord, then dispose of.
It is disposed of. Although it is disposed of, it will be listed again with the report.
Yes, my lord.
Otherwise, we will not know.
And my
We'll
lord,
sleep
matter
over
is-
the matter. Huh?
They will, if, though their bail petition is allowed, my lord, then
Though this bail petition is allowed, granting the privilege of default bail to the petitioner, full stop, comma, this petition be again listed on the 1st of March 2026, on which day the learned PP shall place the report of the Superintendent of Police before this court. Full stop. It is made clear that the Superintendent of Police shall ensure that the process of investigation is completed. Investigation into the manipulation of the date is completed prior to that day. Full stop. Yes.
a copy of the order, my
A
lord.
copy of the order be supplied to Mr. K.K. Parashar, learned APP, for him doing the needful full stuff.
Do you think, my lord, he has to allow to go on bail, subject to furniture of bail? bond,
No,
my lord?
that part I just said that we'll fill it up inside.
Acha.
He'll put in the conditions and everything,
Oh,
we'll
fine.
just put it up.
But even if, what my learned friend has said regarding default bail. petition,
Ah,
Lord, I have the another judgment of Robindran, my lord, what I have given.
yes.
The conclusion there also, what has happened regarding timing, my lord. Exactly it fitted in my.
No,
case.
but no, he's trying to,
Yes, sir,
he has disputed the date.
Yes, sir.
We count third as the first day or we count fourth as the first day. That is your contention.
Ah,
So that part we are not going
Even
into.
if, even the court below has, but session judge also said the one.
Hmm.
If it is one also, if you lordship kindly see that the paragraph.
Had
conclusion
it been,
paragraph-
had it been a petition where that
Ma-
calculation was under challenge
Yes, my lord, that-
appropriately,
that will be a-
we would have adjudicated it.
Correct.
Here is the question whether you are entitled to bail or not.
And-
Why burden the court?
No, that is why, Willard, I referred to also, what,
Yes,
there
yes.
are two things, Willard, that referred also this, 2021 Supreme Court.
All these arguments will come up in in an appropriate petition where particularly the calculation part is being challenged. We can adjudicate that. But here is a question where it was a
Yes.
bail petition that whether you are entitled or not.
Or
When
not.
we find you entitled on one ground,
That is the part, sir.
the part chargeship.
Oblige.
Mr. Parasar,
Well, I,
we could have called for the records, seen for ourselves whether manipulation is there or not. It will only harass the entire system.
no, my lord.
Let it be done at peace. Therefore, we have not called for the records and we have trusted
No,
the
no,
legal senior counsel.
that is what you have been submitted, and what I just been reflect to the, my petition. The- overlook there.
Yeah, he has overlooked.
I'm obliged, Willard.
Yes. Yes, madam.
My lord, this is the POXO case filed under 483.
Hmm.
This notice may be issued.
Heard Ms. So-and-so. Learned counsel appearing for the petitioner also heard the learned PP. Cases under an application under 483 first page of Takibuna, where the petitioner is arrested on 21/7. Issue notice to the respondent number 2 under prevalent notification.
My lord, yes,
Call for the seat, charge sheet
After Bihu,
after
Bihu.
Bihu. Yes, call for the scan copy of this one, so list after the Bihu vacations. We'll have it on 21st. 21st, 21st of January 2026. Yes.
10-6.
Not yet. Yes, sir. Hmm,
Oximeter, your lordship.
huh?
Oximeters.
Ah.
Oximeter. As, CD may be called for and notice may be issued, your lordship, at this point.
Yes.
483 application lordship, FIR page lordship, 17 lordship.
Huh?
17 FIR lordship.
Ah,
The allegation is lordship one Manoj Boro.
huh?
May I read lordship, FIR lordship?
Yes.
I beg to state that while I was on round duty along with.
Similar matter, we had disposed of that gas cylinder.
Yes, lordship.
Gas cylinder matter.
Yes, lordship, on 9.
What, Sherali?
On 9/12.
Why was it, why were they, why were you picked up?
Lordship, actually, my name is not in the FIR lordship.
Uh-huh.
And the allegation is lordship, as per Broding, I purchased a cylinder from the accused some
From one of the accused.
accused Nitul Boro lordship.
So
sold
how-
to Deep lordship.
How long have you
All
been
the
inside?
Cylinders been recovered from them lordship.
Huh?
Nothing has been recovered from me lordship.
That's the cylinder that you bought, has it been recovered? That
No,
must have
no.
been recovered. Even that is not recovered.
No lordship. It's a
That
very-
other order, the earlier order, do you have that 9th of? Mr. Parasar,
That,
everybody is bringing
Yeah.
cylinders to home.
he was the, he was working in a dhaba or somewhere, Now,
Yes.
what he is.
Acha, this page 20, why does it not contain a date anywhere? What kind of 47 notice is this?
Yes, sir, notice.
No piggyback riding. I point out something, you can't ride on that. You did not point it out, yes? BK heard Mr. So-and-so learned counsel appearing for the petition, also heard Mr. KK Parashar learned PP appearing for the state. Application under so-and-so, it is logo. Bill for the petitioner, namely Tamchar Ali. In connection with the same case, huh? Allegation against the petitioner is reflected in the as reflected in the as reflected in the notice under section 47 BNSS is that one of the stolen cylinders was allegedly bought by the petitioner from one of the persons who was accused of having stolen the cylinders, full stop. The counsel for the petitioner submitted that that the petitioner has been arrested on 19/11/2025 and that the notice under section 47 of the BNSS is devoid of any date, comma, raising doubts on the day on which it was supplied to the petitioner, full stop. The learned APP has objected to the bail petition by stating that the matter is still under investigation and releasing the petitioner at this point of time may hamper or temper the investigation, full stop. We have considered the submissions made. Itu di bawah. I'll take my edition, huh? Petition allowed.
Hello.
10,000 surety of the like amount. Yes.
Your Lordship,
Hmm.
Lordship, commercial quantity and DBS Lordship, CD may be called for,
Not charge sheeted.
not charge sheet.
Not such.
CD call query go to, but Mr. So-and-so. Gauripur Police Station case number so-and-so under the NDPS Act.
20.
Mr. PP 20th of January 2026, huh? Yes.
May it please your lord.
Yes, sir.
My lord, item number 9 and 15, my lord, arise under the same FIR, my lord, but
Hmm.
15 we are not pressing today, my lord, we may be allowed to withdraw, my lord.
Why?
My lord, my lord, we'll have to, my lord, modify the, my lord, petition.
But the truth, whether some other petition was pending when that was filed. Is that the case? We need to find out.
My lord, we will have to, my lord,
Was another petition
my lord, was
pending?
disposed
It
of,
was
my lord.
pending, so we are not allowing you to withdraw the same. We are keeping it for tomorrow. The other matter is also supposed to come up when?
No, not pending, my lord.
There was no other bill
No, no,
petition
not
pending,
Pending, my lord, not pending.
disposed of,
Disposed of earlier, my lord.
and that was not reflected.
No, my lord. But not pending, but disposed of, my lord.
Item 15, learned counsel for the petitioner submits that due to inadvertence, certain vital facts regarding disposal of earlier matters had not been incorporated and therefore prays that he may be granted the liberty to withdraw the petition on behalf of the petitioner
We-
and
we might
file
need to
afresh
correct.
by incorporating all necessary material, full stop. Prayer is allowed as prayed for. 15. What do you say about 8? Yes.
My lord, 9, my lord,
Hmm.
it's a bail application, my lord.
Hmm.
Your driver and handyman, my lord. And
Hmm.
they have, my lord, 17 kettles were recovered from the vehicle, my lord. We have all the valid documents, my lord. I have annexed all the valid receipts, my lord. The receipt starts, my lord.
That is that one, a vehicle was intercepted, manner, 17 cattle were recovered, manner, from the, manner, said vehicle, manner. Now, Lordship may kindly turn to page 18 onwards, manner. 18 onwards and 19 is the, manner, the received, manner. And manner, it goes, 17 cattle we have duly purchased, manner.
Have these, did you approach the trial, other courts
No.
saying that we have the receipts and we can be allowed the bill?
No, manner. We have-
How do we verify the authenticity of these documents now,
But
sitting here? When were you arrested? 25/11.
16, 17 days in custody, my lord. And cattle has already been recovered, my lord. There is
It
nothing
has
much-
recovered, but thing is that in case of owner, the owner says that we don't know what the driver is doing, matlab, because now they are driver and handyman. They are loading 17 numbers have come in a single truck. Cruelty, matlab, definitely.
Cruelty, portion may be there, my lord. It is bailable, my lord.
Huh?
But
The cruelty portion is bailable, no
but,
difficulty.
my lord, here, my lord, but these are not stolen cattle, my lord. We have all the valid documents.
Why don't you try to find out whether this, name of the seller and name of the purchaser?
But seller, that item number 15, which I have, withdrawn, my lord, recently.
No, that is okay.
That is Hamidul, my lord, that's a.
Uh-huh.
My lord,
No, seller, we don't have a problem.
But
Why should he be
purchaser-
running around if he has sold it?
Purchaser, Hamidul, my item number 15.
Uh,
He is the deals with cattle and goats and buffaloes, my lord. He purchases, my lord, these are not stolen, my lord. These are not stolen cattle, sir. But he has.
when would you be in a position to file the other one?
But my lord,
The other AB?
but today, as soon as my lord signs the order, my lord, we'll file it by tomorrow or my lord. But here, my lord, their driver handyman, poor driver handyman, they have been, my lord, asked to, my lord, transport the vehicles by Hamidul, my lord. And my lord, they have carried and they are
17 numbers of vehicle in,
the 70 number of cattle, man.
or 17 number of cattle in
But my in
what
a
vehicle? Truck?
Truck, my lord, truck. But
In a-
cruelty portion may be there, my lord, that I am not.
In a
able to
goods
define, my
carrying
lord.
vehicle, not more than
Truck.
6.
Hmm?
In a goods carrying vehicle, not more than 6 is allowed.
But that cruelty portion is there, madam. That I am not, but madam, poor driver, handyman, madam, they have been dictated, madam.
The cattle are more poorer.
Like, yes, madam, I agree, madam, but madam, here, madam, detention may not be required, madam, because the alleged cattle have already been seized by the police, madam.
No, apparently if he is the purchaser, he is yet to be interrogated.
Yes, madam, but.
Who
first,
the
madam,
person whose
that's why
vehicle
we
it
are
was,
pressing His bail
the
application.
cattle, huh?
That's why we are not pressing his bail application, but he regularly purchases cattle, madam.
Why, Mr. Parashar, I think we can keep this for next week. Or maybe immediately on the reopening. Let him have this other AB also. CD can come together. And at least by that time, if you can have the statement of Hamidul Ali recorded, we can consider this bit.
When it will be filed.
Madam, we'll find
No,
it,
give us a suggestion because
but madam, looking the driver handyman, madam,
they were found directly in possession of those cattle and they could produce nothing.
Admittedly, they are a driver and handyman.
Smart people would have at least asked for photocopy of the receipts with the manner in which they are being caught now. Someone would be carrying some papers. People would be carrying, they would be smart enough to carry some papers. But to find out whether we'll have to let them have
Maybe on
go whether this
17.
23/11. See, this cattle is bought only 2 days before,
Yes, yes.
as per the receipt.
Why
Why does it happen every time?
But
Huh?
Hamidul, madam,
Document always comes.
admittedly, he purchases cattle.
You file the other bill petition, we'll take up both of these together, we'll call for the CD together and we'll,
Madam, here, madam,
otherwise, if we allow this now, the plea here would be persons carrying it are allowed, so please allow us. It becomes a dicey situation for us.
That he is the madam, genuine purchaser.
We'll have this on one, yes, Mr. Parashar.
17, CD?
Huh?
CD, say 17.
17th CD.
17th, madam. Okay.
You have your other AB also listed on that day. The CD would be here. We can consider all three at a go. Heard Mr. Swensol and the council appearing for the petitioner also heard AP Parashar, APP. Call for the CD list again on 17th. of December, full stop. Yes.
Oblige, your lordship.
Item 50.
Yes.
May I please?
Hmm,
My lord, this is regular bail application, my lord. I am behind the bar since 25 days. The
25 days.
alleged stolen vehicle as well as the materials recovered, my lord. So further custodial detention may not be required, my lord. FIR is at page number 10.
Vehicle was recovered from you.
My, no, my lord. One driver, Manospati Boruga, my lord, Dwara, my lord. Page number 14, relevant portion is at 14, my lord, FIR. Informant suspected that the driver Manospati Dwara has stolen away the vehicle as well as the materials.
Manaspatim Dora is a driver.
Yes.
Page 17.
He
Matlab.
was a driver of that.
17 forwarding report. Page 17.
Huh?
Forwarding report. Stolen vehicle with aluminum electric conductor has been recovered
Mm.
and statement of the accused, yes, Sadul, he is the petitioner, was
Yes,
involved in the theft. He is involved in the theft. Manaspatim Dora is the driver only. Matlab.
My lord, may I read the FIR, my lord? Second para, my lord, today morning our driver.
We will require the CD, sir.
My lord, kindly 25 days, my lord. Already the stolen vehicle, my lord, may I read it for a moment, my lord? Second para of the FIR, my
CD
lord.
call for it. Heard Mr. So-and-so and a council appearing for the petition also. Heard learned at APP, the application under 483, BNSS, Bongaigaon PS case number so-and-so. The allegation in the FIR reflects that a vehicle was stolen from the premises of the informant. And when the police, on recovery of the vehicle had also recovered what was recovered? Electric conductors, etc. Full stop. How is this Saidul connected? Why
Well,
was he
I have-
arrested?
My lord, I am.
He was driving the
No,
vehicle.
no.
Then?
My lord, I am a laborer of the tower, my lord. My lord, so that my lord, kindly for a moment, page number 14, my lord, third paragraph. I hereby like to state that we have doubt that our driver.
Page number?
Dwara, my lord, 14, 14.
1-4, yes.
Third paragraph, my lord. I
Ah.
hereby like to state that we have doubt that our driver, Mr. Manospati Dwara, along with. some of his
Why he has been
associates,
arrested, we must know why Saidul has been taken into custody. Who was he?
My lord, he is a laborer.
Where have you stated?
My lord,
Where have you
paragraph 7,
stated
my
that
lord.
he was a
Page number
laborer?
5, my lord. That the petitioner begs to state the petitioner is in no way involved in the alleged offence, but in fact the petitioner is a laborer of Tower Construction Company who was working near a Dangatal police outpost under Bongaigaon police station, but the investigation agency called the petitioner at the aforesaid police outpost for
Para?
some para 7, my lord, page number 5 of my petition, my lord.
Let us see the CD. When? Well, for the CD, when?
My 18.
18th.
17, my lord, if it possible.
Case of direct involvement.
17, 18 kolo aru. 18 kolo aru.
My lord, hello.
Huh?
Hello, please.
Yes.
It's a regular bail application. One young couple eloped out of their own volition with the intention of marrying each other.
Hmm.
When a mother filed the FIR, said that they fled away for marrying. Now, very unfortunately, the girl age is 17 years, 11 months and 23 days. 7 days fell short of adulthood.
I
Now,
missed
POCSO
my
section,
I missed my first voting by 3 days.
Now charge sheet has been
Date is the-
submitted, charge has been framed.
Hmm.
More than 3 months I'm behind the bars. I'm unable to defend my case properly due to my long incarceration. Yeah,
From when are you behind bars?
I am from 3/9/2025.
3/9/2025. What does the girl say? Any statement given here?
164 statement is not provided. Since POCSO section.
Notice has to go if POXO is involved.
POCSO is invoked.
6 of POCSO is there, 17.
May I also fix on 18th, LCR may be
Well,
called scan
he-
copy of. the
18,
LCR.
we are
Ye-
keeping the next week as a motion day for motion matters. And fill it
here-
up with
Like,
all these matters.
take a
Fifth,
chance
As
if
per
you
the
the-
part of the charge sheet, 17 years, 4 months. মানে he said
8th of January আছে তো জাগা? অলপ চলপ? আছে। There is some space for you on 8th. Yes. 10, yes.
May I please, Your Honor?
Hmm,
Anticipatory bail petition, my lord, FIR is in page number 13, my lord.
hmm,
This is the type copy, my lord.
hmm.
May I read? Respect.
Page number?
13, Annexa 1.
Yes.
Respectful submission is that regarding the above reference on 14/11/2025 at 9 PM. Well, I, ASI Pranjal Soikia, with the officer in charge of this police station, along with personnel of half section 12 AP battalion, was in Naka checking duty at 15 number National Highway under the jurisdiction of the said police station. At around 11:30 PM, at first we stopped an Alto vehicle having registration number so-and-so, coming from Gokpur side towards Biswanath Sayali. And on being interrogated, the driver and passenger, we came to know that the cattle are being brought from Silapothar, Dhemaji, loaded in 3 trucks. After getting the information at around 1:30 AM, we intercepted 3 numbers of trucks having registration numbers so-and-so, which are illegally tied up in unhealthy and painful conditions. Immediately, the officer in charge informed the higher authority and interrogated total 16 numbers of people, including the drivers, and asked to produce documents regarding carrying the cattle. But the drivers and the helper could not produce any documents. Therefore, there is full potential that those are stolen cattle. Total 16 people along with the driver has been taken into custody. For
Why do you apprehend arrest, sir?
Because some of the kettles are mine, my lord. I purchase, the petitioners purchase some kettles, although we want to approach before the police station to produce the receipt, my lord. But one of the owner has been already arrested, so we apprehending arrest. Also, we want to seek Jimma of the kettles, but due to the apprehension of arrest, we could not go out, my lord. All the.
Yes, sir, they want to go before the police.
my lord, page 17, the vernacular portion of the FIR. In
Hmm.
3 vehicle, in 1 vehicle 35 cows,
all
1
my lord,
vehicle
includes mine, my lord.
39, and in 1 vehicle 24.
My lord, I have stated in paragraph.
তিনিখন গাড়ী ৰখাই গাড়ীখনত ৰখাই তালাচী চলাওঁতে অনৈতিক অস্বাস্থ্যকৰ আৰু যন্ত্ৰণাকাতৰ পৰিৱেশত ইমানখন গাড়ীত 35টা ইমানখন গাড়ীত
Even if cruelty to animal is bailable, there has to
39
be a limit to the cruelty.
Kettles are not mine, my lord. There are.
How
4
many kettles did you have?
for the
How many,
petition-
how
for
many?
Petitioner number 1, there are 15 kettles.
15?
Petitioner number 2, 5 kettle.
Hmm.
Petitioner number 3, 6.
Hmm.
Petitioner number 4 have 8 kettles, my lord.
How many more do you need to be taken in a truck?
Maybe, my lord,
20,
the driver,
26,
some other
30
person
something.
contacted the driver, my lord. Maybe other person's kettle will be loaded, my lord.
Hmm?
Maybe others person kettle may be loaded in the, my lord, vehicle, but for that, my lord, driver is responsible, not.
What do you say?
But we are, want to approach
driver-
for the.
First
police,
of
my lord.
January, first week of January?
Verify, my lord.
Huh?
মানে
Adi.
মানে 10, 12, 15, then also cruelty, মানে 35, 39.
That's correct, but we have approached the driver for our kettles, my lord. The driver may contact with other persons, my lord. Reality has been done by the driver, my lord.
These
We are one to
these are not cartoon boxes where you fill it up in the truck and forget about it.
I understand, my lord.
These are living things.
My lord, I understand, my lord.
Don't tell us that part. We'll wait for the CD on the first week of January.
মানে it's a AB, মানে
Huh?
it's a AB first week of January, 4th, মানে 4th, no.
We want to.
Six.
fix Jimma, but my lord, because of this.
Cover six,
apprehension, my lord.
Where are the cattle now?
Taken
taken care of.
Cattle were seized, my lord, these were handed over to some, there will be some NGOs
NGO.
interested in this regard.
They are
We
being,
have to
they are
take-
being taken care of.
For that, we have.
They
to
will
pay,
leave.
my lord.
Huh?
For that, we have to pay ultimately if we get the Jimma, my lord, because of, that's why, my lord. We want to file the Jimma petition because of apprehension of arrest, my lord. They can verify the documents, my lord.
First week of January. First week of January, did you call for the case diary? First week of January.
7.
বাকি details কিন্তু পাই যাব ন?
That 6 or 7.
6th of January? 6th of January. Huh? Don't think so.
Apply, sir.
Because you buy the cattle just 2 days before the arrest and the document comes into existence just 2 days after the arrest.
So,
That
my
is the
lord,
whole purpose.
FIR was lodged on 18, my lord.
Huh.
Kindly have a look, and the allegation is that in 14/11, that was seized. FIR was of 19.
Ah. And when did you buy the cattle?
18, my lord. So the FIR is also some
We'll
contradiction.
consider on 6th. We'll consider. We have been considering, we'll consider if we find anything, where we can let you know.
Anyways.
11 can be after sometimes, man.
11. Okay. Diok of speed, Diok. Yes, 12. Yes, madam.
This is an application of pre-arrest bail. Lordship.
Ah,
Lordship, the petitioners number 1 and 2 are husband and wives. Lordship, FIR is at page 20, Lordship. Effective portion type copy is at page 22. Lordship, FIR has been filed by the SI, the police officer of a police outpost, Lordship.
Page 22. What happened?
Your Lordship, the allegations are that the petitioners had, Lordship, indulged in some violence in the police outpost, but Lordship, the real fact is that, Lordship, during the Rakh festivities, Lordships, the police officers allowed some shops and vehicles to be parked in front of the house of the petitioners. Since when they could not, Lordship, use their own gate, the police petition number 1 had complained to the police person who was present in the police outpost. But Lordship, when they found out that the petition number 1 is an advocate, Lordship, they took it personally and they threatened the petition number 1 that they'll arrest him, and they sent him back. Later at night, Lordship, they again forcefully called the petitioner who was out with his family, Lordship, to watch the festivities. Then they indulged in violence. Lordship, petition number 1 and petition number 2 is the wife. Both were, Lordship, physically.
Submits that the petitioners apprehend arrest in connection with Juria Police Station case number so and so. Full stop. The petitioners are husband and wife. Husband and wife. And she submits that due to some altercations which had taken place regarding parking of cars during the Rakh festival inside, outside the gate of the petitioner's comma. The matter was reported to the police. Full stop. The learned counsel for the petitioner submits that although the petitioners had initially visited the police station, no further action was taken and they were allowed to go.
Lordship.
For
then they were asked to
asking
leave.
that the matter be compromised. But however, late in the night, an FIR was lodged against them.
No, Lordship.
Huh?
Lordship, petitioner went to complain in the evening. He was sent back. He was threatened that he'll be arrested and he was sent back. Then at night, when they had gone out to watch the festivities, he was pulled by his collar. He was taken to the police outpost. Then the petition number 2, the wife, along with his mother, they all went to the police outpost when they heard some altercation inside. Then, Lordship, even the petition number 2, who is the wife, Lordship, she had injury in her head. Her hair was being pulled by the inspector, Lordship, all the
No,
altercations.
these are allegations we would not like to go into while considering the bail petition. What do you think?
It was filed on the next day at 1:30 PM.
Stop, no, when the petitioners had gone to lodge an FIR, it was refused, but on the next day, it came to light that an FIR had been lodged by the in charge of the Dogaon PP against the petitioners alleging verbal abuse. Verbal abuse, full stop. And also manhandled a few of the police personnel, full stop. The learned counsel for the petitioner has submitted that the FIR does not reveal that any attempt was made to detained the petitioners on 1/12/2025 itself when the alleged incident occurred, and instead the FIR has been lodged on the second day, which creates a doubt. Full stop. The learned APP has submitted that the allegations are grave to the extent that that the petitioners had assaulted and attacked police officers inside the police station premises itself, and therefore releasing them on bail at this stage would not be in the interests of the case, investigation of the case. Full stop. We have considered the submissions made by the councils, the petitioners are here, who is the investigating officer here?
Lordship, investigating officer, Lordship, Saddam Ansari is entrusted to investigate the case at page, Lordship, 22B.
22,
B,
yes.
Lordship, on the left side below, Lordship.
Call for the case diary. List again on,
After Bihu,
after Bihu. 22nd,
well,
22nd of January 2026, full stop. In the meantime, the petitioners are directed to appear before the learned, before the investigating officer of Juria Peace case number so and so. Full stop. In the case of their arrest, it is provided that they will be released on bail of so and so. Yes. Go and appear within 7 days. Have your statement recorded.
Deeply obliged, ma'am.
Here, my lord, I am the owner of the vehicle, my lord. The owner of the cattle has been granted Jimma. He took the vehicle, took the cattle, my lord. He has been granted free arrears bail. Now, my lord, I am the owner of the vehicle, my lord.
Hmm.
Case 14 is the FIR, my lord.
You have nothing to do with the cattle.
No, my lord, cattle's Jimma pays 27, my lord. It has been given to the owner. And he has been granted free arrears bail also, the owner pays 29.
Yes, how many times before this has this truck been used for?
No, only once, my lord, that morning I have genuinely submitted the Hamidul, he used to purchase, my lord. That's why cases are pending against him. But here, my lord, he is the owner of the vehicle, and page 15 is the Jimma order. Jimma has been granted, my lord, and page 29 is the.
You have received, you have got the Jimma of the truck,
But not me, my lord, the
owner of the cattle.
cattle. he has
No,
got-
about the vehicle.
But vehicle, if I am not protected, my lord, if I apply for Jimma, I'll be put behind the bars, your lord. That is the.
Yes, sir.
my
Owner
page-
of the truck,
Page 29, my lord, is the owner of the vehicle.
cattle gone.
Zimma
What to do?
Jimma allowed, and pre-arrest bail also allowed to the owner of the cattle.
Owner of the cattle.
what remains, my lord?
Yes, had Mr. Swansel and counsel appearing for the petitioner. Also had the learned APP. Full stop. The petitioner claims to be the owner of the vehicle in which allegedly stolen cattle had been transported. Full stop. The learned counsel for the petitioner has drawn the attention of this court to the order dated
Ordered 14/12/25.
14/12/2025.
4/12, my lord, sorry.
No, this is
4/12,
this is 2/12,
page 27,
page 20.
27.
No, to the order dated 2/12/2025. Passed by this court in AB number 2815 of 2025, whereby he submits that the owner of the cattle had been granted bail. Full stop. He has also referred to the order dated had been granted anticipatory bail. Huh? He has also referred to the order dated 4/12/2025, passed by the Subdivisional Judicial Magistrate number 1 Kamrup Metro, whereby the Zimma of the cattle has been handed over to the person claiming to be the owner of the cattle. Full stop. The learned counsel for the petitioner submits that in the present situation, the owner of the truck, who is the petitioner hearing, may also be granted the privilege of pre-arrest bail so that he may participate in the investigation process and also pay for Zimmer of the vehicle, etc. Full stop. The learned APP has objected to the prayers made, saying that the vehicles, if released, if the owners of the vehicles, no, that allowing the privilege of pre-arrest bail to the petitioner may hamper or tamper with the investigation. Full stop. We have considered the submissions. Prayer for pre-arrest bail is allowed. And the document is way took. Announcing a bond of 30,000. He shall appear before the IO within a period of 7 days.
Oblige your lordship.
Disposed of, disposed of, huh?
May
Yes.
please your lordship.
Ah,
Here, my lord, whatever, my lord, the petitioner has purchased, my lord, 3 numbers of mobile phones, my lord, admittedly, my lord. Then there were some technical glitches, my lord, he could not pay, my lord, but the payment was made, my lord. Then, my lord, the owner became agitated, my lord. But later on, when he paid 90,000, the remaining 1,20,000 he is yet to be paid, my lord. Yet to be paid, but his bank account got freezed, my lord, because he now, as he paid the 90,000, the very next moment, his account got freezed, my lord. Now I'm categorically stated, my lord, I'm ready to pay the remaining amount of 1,20,000. 90,000 I've already paid. I have, my lord, that is at page 18, my lord. And the mobile received, my lord, that also I have annexed, my lord, the
mobile received by whom?
Pays, annexer to pay 16 onward, my lord, the money received, my lord, the mobile, my lord, the cash memo. And my lord, 90,000, my lord, I have already paid, my lord, and remaining I am ready to pay. I have categorically stated, my lord, on oath, my lord, that I am ready to pay, my lord, but my lord, my account go to get that. If lordship, my lord, I'll record my submission, my lord. I am ready to pay the remaining amount.
They're now ready to pay the remaining amount by when?
But
Pay.
now, my lord, if I go there, my to be frank, the shopkeeper is very agitated, but he don't want the amount, he wants me, my lord.
Transfer the money like you transferred it on the last occasion.
Lordship may kindly see the pays, my lord, please, for a whole bit. 90,000.
90,000, page 18, last page.
Pays paragraph 5, my lord. And 90,000 I have paid, but but the police has freezed my account, my lord. Paragraph 5, my lord. Cash also, my lord, if my lord, it may be recorded and I'll pay.
Send it to someone else.
No, my lord,
To the police
they
station.
want me, my lord. Lordship may protect me, I will, but if you record my submission, my lord, I will pay 1,20,000.
When?
Oh, but if Lordship gives, within 10 days, my lord, within 10 days. He will
We'll
get
allow
back.
him to appear, let him make the payment within
Yes,
the
my
10
lord,
days.
Yes.
And you will also give his statements and all. But unless you
Yes,
pay
but
that.
if I won't pay, my bill will get cancelled, my lord.
It may not be finalized, my lord.
Huh?
May not be
It will
finalized.
be pending. We'll
yes,
call
we
for the
talk-
CD. Heard Mr. So-and-so learned counsel paying for the petitioner, also had the learned APP full stop. The learned counsel for the petitioner has submitted that the allegations in the FIR are to the extent that the petitioner had taken 3 mobile phones from the informant. And on his failure to return the same, the informant had lodged the aforesaid FIR full stop. The learned counsel for the petitioner submitted that he has already paid an amount of rupees 90,000 to the petitioner, to the informant.
Informant.
And he is ready to pay the rest of the amount to the petitioner. However, since his bank account has been frozen due to this case, he is not in a position to make the electronic transactions. Instead, he has stated that the petitioner would be ready to pay the rest of the amount to the informant within a period of 10 days in cash, in case he is allowed to, but he apprehends that on his appearance, he may be apprehended in connection with the aforesaid case. Full stop. Call for this case diary. List again on,
27th.
in the interim, it is provided that the petitioner shall appear before the concerned police, concerned investigating officer to have his statement recorded and also to pay the amount of rupees, remaining amount of rupees 1 lakh,
1,20,000.
1,20,000 to the
To the owner
informant of the, to the informant. Huh? Full stop. It is provided that in case the petitioner makes the payment of, in case the petitioner makes to fail, fails to make the payment of rupees 1,20,000 to the informant in the presence of the police, of the investigating officer, comma, the privilege of interim protection given to him shall stand withdrawn with immediate, from the expiry of the 10 days. Full stop. List this matter again on. When, Mr.?
27th.
27th of January 2022.
Like-
2026.
There was 16.
Allegation is not of theft. He was given the mobile. Yes,
Your Lordship.
yes.
It's on your Lordship. And page number 20, Zimma for, one is the Renault Duster car vehicle bearing registration number BR01, DA6016, and one Redmi mobile handset bearing IMEI number so and so, and rupees 42,000, your Lordship.
Hmm.
And the FIR is your Lordship. Page number 13, your Lordship, mention your Lordship. First para of the last line, case of rupees 42,000 were recovered from their position, your Lordship.
Hmm.
And your Lordship, page number 13, clause A, paragraph number 2, one Renault Duster car bearing registration number BR01DA6016, along with key. Description of the recovered article. And paragraph number 5, one Redmi mobile handset bearing.
We'll have to call for a report.
Lordship, scan copy has been called for. It is the charge sheet already submitted. I have
Charge sheet
checked the charge sheet also, your Lordship.
The cash amount, what?
Charge sheet is page number 21. And your Lordship, already the accused persons are granted bail by the Honorable High Court. They are out of the custody. So in any condition, your Lordship, Zimma may be allowed.
Zimma in respect of the vehicle cannot be allowed, Lordship. If Lordship kindly comes to page 18 for a moment.
18, 1/8.
Yes,
Yes.
this is the earlier Zimma
Hmm.
petition. The order was passed. Lordship will kindly peruse paragraph 5.
Hmm.
This is the trial court rejected order, your Lordship.
Yes, so Lordship will kindly see that he himself.
Vendor of the car.
Yes, he himself is the owner of the car and it was from his position that the contraband was seized.
But
Now,
they
in
are
this-
listed
and-
by.
Let's- In this respect, Lordship will kindly go through the judgment of Biswajit Dev versus State of Assam. If
Vendor of the car, you are using the car to conceal it, not to carry it.
yes,
Car goes.
yes.
Mobile,
No, it was similar.
Mobile in rupees 42.
42,000 we can consider. If you give enough surety for the 42,000.
That
Because I
Lordship,
think cash has to be given back so that it is not destroyed in safekeeping. It will be your responsibility. If you keep the cash, it will be your responsibility. It has to be,
in respect of the vehicle, Lordship, I am stating, Lordship will kindly peruse the paragraph number 29 for a moment, Lordship.
yes.
After discussion, Lordship, I am not bothering your Lordship with the other discussion.
Hmm.
Lordship will kindly see, broadly speaking, there are 4 scenarios. Lordship has found it.
Paragraph
Paragraph
number 29.
29, Lordship.
Ah,
Broadly speaking, there are 4 scenarios. Though seizure of drug substance from conveyance can take place in a number of situations, yet broadly speaking, there are 4 scenarios in which
Hmm.
the drug or substance is seized from a conveyance. Firstly, where the owner of the vehicle is the person from whom the possession of contraband drug substance is given. So the petitioner is the first scenario, Lordship. Second scenario, Lordship, where the contraband is recovered from the possession of the agent of the owner, like driver, cleaner, hired by owner. This is not the second petition. That is,
so vehicle goes.
yes.
The mobile phone,
In that respect, Lordship.
if you have recovered whatever is required to be recovered
If-
from the
if
mobile
recovered,
phone.
Lordship.
You have submitted a charge sheet. What more will you recover now?
Yes, then.
What more will you recover now? Nothing else. You cannot recover anything more. It will be all electronic record which you have already taken. So the mobile can be,
Lordship,
Mobile in
Even-
rupees 42,000.
and the 42,000 rupees with enough surety she will take
Yes.
back. And the mobile phone also with sureties.
Lordship. If required, they will produce it before the court.
As and when required.
As and when.
But what about that cash amount?
Cash amount can be given, Lordship.
42,000.
Or Lordship can direct the court below to consider in respect of these two articles, because the trial court will be in a better position to set the conditions regarding the release of the.
Whether that was the money recovered from the vehicle or not would be one
Yes.
of the questions they will try to
Yes.
raise. Once the money is gone, they will
Yes.
not be,
Let
will
the
not be.
trial
able to-
court decide on that aspect.
Or you
also.
can take down the details of the notes.
So Lordship, we can prolong the matter here, we can, it will be like.
What do you want to do? Mobile you can return because charge sheet has been given. Huh? Tell us.
Lordship, my prayer will be regarding the vehicle, it is clear. The other two matters, Lordship, let the trial court take a fresh decision in view of the charge sheet being laid down.
Yes, take down. Heard Ms. Swensel and counsel appearing for the petitioners, also heard Mr. Swensel and APP. Full stop. This application under 528 of BNSS has been filed by the petitioner. 25 million. Impugning the order dated so you take down from order dated 10/11/2025, huh? The scan copy of the case diary and the scan copy of the records of the trial court has been, as has been called for, has been received, full stop. On going through the contents of the criminal petition, comma, consideration of the submissions made by the learned counsel for the parties, comma, this court is of the opinion that in view of the judgment and order dated so and so,
Yes, Lordship.
can you read the details too? Huh? The Zimma of the vehicle involved in the
Lordship, that is
case,
2025 3 SCC 241.
huh?
This
Para
was in-
29,
Yes.
para 29 and 30.
That may differ, Lordship, because this is the court's order in the.
No,
journal.
we are just keeping a track.
It is-
29 and 30. The Zimma of the vehicle involved in the case would not be, it would not be appropriate to award Zimma of the vehicle involved in the case, full stop. However, it is seen that the case has already been charge sheeted and the requirement of production of the mobile phone during the trial can be ensured with strict conditions being laid upon the owner of the mobile phone. If the learned trial
In case
court,
of rupees 42,000.
in case the learned trial court so finds, it full stop. Similarly, in the case of the cash having been recovered from the accused, comma, they also may be handed over to the, they also, the learned trial court may also consider the, consider handing over Zimma of the same to the petitioner by imposing such conditions as are required in law in such similar cases, full stop.
Lordship, one thing, Lordship, it is not clear whether confiscation proceeding has been initiated, because that would give rise to another situation.
Full stop. The learned trial court would also take, the learned trial court would also be in a position to take into account as to whether any confiscation proceedings have been initiated regarding the vehicle, the mobile phone and the cash amount involved, full stop. In view of the above, this criminal petition is disposed of by granting liberty to the petitioner to approach the trial court by filing appropriate applications, since now the charge sheet has been filed. Right. Full stop. The learned trial court on such applications being preferred shall consider the prayers without reference to the earlier rejections made and the disposal of this criminal petition. Full stop. In case the learned trial court finds it fit to allow the Zimma of the mobile phone and the cash amount during pendency of the trial, comma, appropriate conditions may be imposed upon the, for their production at the time of trial or at the time of the, for confiscation if the situation so arises, full stop. Criminal petition accordingly disposed of. You appear before the
Lordship,
trial court.
the amount of which may be mentioned before. the-
Amount of rupees 42,000.
For addition, item 19.
Yes, sir.
Criminal petition arising out of land grabbing case.
Huh?
It's criminal petition arising out of land grabbing case. They filed the land grabbing case against us. And we approached the zonal court, and the zonal court earlier, there is a stay. So far the land grabbing case 12 is concerned. There is a stay order. And factual background, my lord, we have.
Are the pleadings complete for all the parties? Pleadings are complete.
And question is separate plot. Our land is quite different, they are also quite different. And in between our land, there is another DAG number. Our DAG number, my lord,
How are we to decide that?
Roshi.
How are we to decide that which DAG number is where?
No, they are pleading and our pleading
Huh?
say their DAG number 489, our DAG number Roshi 491.
Huh.
489 and 491.
Hmm.
That in between these two DAG, another DAG 490.
Hmm.
Now they're saying that we jump to their land. We have our own land, so far the.
Yeah, these are questions of fact to be decided on basis of evidence. How do we go through and criminal petition do?
Depends, my lord, whether the land grabbing act is accepted or not. Nothing, because there is no any criminal intimidation appear. There is mandatory. Criminal intimidation is to be attracted, but here, so far their case is concerned, there is no any such contention.
There is no contention in the petition at all.
Regarding criminal intimidation, whether criminal intimidation attracted in this case, that is to be decided upon. If so.
If there is no criminal intimidation, there will be no
then-
land
then-
grabbing
then
process.
Land grabbing cannot be attracted. So this is, my lord, one of Supreme Court also decided in this case.
Is it so, sir? Unless there is an intimidation, there cannot be land grabbing. Can it be so?
Yes.
Eh? It will lead to a very anomalous
Let me see
situation.
page number 23, man.
Para 6.
As specifically stated, man.
The smooth criminals who do not intimidate will then go scot
Criminal
free.
intimidation. means-
Yes, where is it?
Criminal intimidation that it requires to specific intent to cause fear or distress.
No, you show us that in a land grabbing case, unless there is an allegation of criminal intimidation, the court cannot proceed. Show us that law. What is
Yes.
criminal intimidation is
Yes, para 6.
para 6. Yes, sir.
I have,
Para 6.
So may I read you, Lord?
Showing that he has unauthorized
Just keep
legally
saying
proceeded
that A
without law-
combined reading of clause D and E would suggest that to bring a person within the meaning of expression land grabber, it must be shown that he has unauthorizedly, unfairly, illegally, snatched forcibly, violently, or unscrupulously any land belonging to the government or a local authority, a religious or charitable institution, or endowment, including a waqf or any other private person, without any lawful entitlement, and C, with a view of to illegally taking possession to such land, or enter or create illegal tenancies or lease and license agreements or any other illegal agreements in respect of such land, or to construct unauthorized structure thereon for sale or hire or give such land to any person, or rental or lease and license basis for construction or use and occupation of unauthorized structure, or he has given financial aid to any person for taking illegal possession of land or for construction of unauthorized structure thereon, he is collectively or attempting to collect from any occupiers of such land, grant, compensation and other charge by criminal intimidation. And criminal intimidation, there should be fair, not mere threat, not mere threat, because their complaint itself reveals, Lordship, that he was in natural environment.
He was in?
He was eventually in good situation, Lordship. Their intention is whether he was in distress or fear, nothing appear. Page 24. Saying that he was attempted to doubt, but he was not in fear, not in
He was
distress.
attempted to?
attempt to lordship page 24, I'm coming to this
Para number?
page 24 in my
Of the
petition.
petition.
Page 24, 2 foot. In
Says to attack with applicant with bamboo stick and dao.
Thou,
Ah,
in the hand of respondent 2, and ask the applicant to leave the suit land immediately, but no distress and fear appeared. And very important, the applicant humbly informed, even though he
the
humbly
applicant from the suitland along examiner to, and thus the respondents also disposes the applicant from the suitland along with the incomplete Assam type house. The respondents said that they would either sell or lease out the said land very soon as the price is going high, and threatened the applicant not to disturb their such illegal activity. You are a respondent.
I am in.
No, here, in this page 24, you are the respondent or the applicant?
They are applicant,
You are respondent.
respondent.
But the respondent denied the right title interest of the applicant, misbehaved using slang languages and chased to attack the applicant with bamboo stick and dao. Yes, so there is no intimidation.
But they are saying mere, my lord,
But just chased, so there is no intimidation.
mere fear is not attracted criminal intimidation. If there is an injury, there is a fear, they must approach before the authority, that is police station.
So
That is not
your,
there.
if,
No case registered against us, whether there was a serious injury, whether there was a serious distress, nothing is there. The mere description. Now, so far our document is concerned, we are in possession to our document, that page 29. We are not on the
ownership.
plot. Without having any.
We'll record your submission that you are not on the plot being claimed by the
No,
applicants.
that not
We
quite-
will record your submission that you never tried to grab the land or that you are in possession of the said land.
No.
And therefore, whatever land is demarcated in favor of the applicants before the trial court, any other person sitting thereon will compensate the applicant accordingly.
Yes.
Will that do?
And our, we are in possession.
No,
so
we will
far-
say that you have made a submission that you are not in any kind of possession, illegal or
Yes, nothing.
unlawful on their
We
land.
are possession to our land, that is
Hmm.
page 29.
Hmm.
Page 29. We have a particular land, and our land, my lord, more than 1 bigger 2 kata 10 lesser, and their land also only 2 kata 18 lesser.
Hmm.
We are a risk person, so far our land is concerned.
Hmm.
Why we will attack 2 kata 18 lesser?
Your
Because
land these
document
days,
saying we are
these days 6 feet of land is becoming rare.
1 bigger 2 kata 10 lesser,
Hmm.
better than, because we have possessed 1 bigger 2 kata 10 lesser, and they possess only 2 kata 18 lesser.
All these are things,
Why
sir,
we don't
all
want this
these
stuff?
are, all these are things which will be taken care of by the trial court. We cannot in a
No, only, my lord,
supervisory jurisdiction.
otherwise fixed for hearing.
To hear what we have heard, we'll hear him.
And
So your ground is that,
to note that we are. in
your
possession-
ground is number one, that you are, that there was no criminal intimidation.
Yes.
Therefore,
So
a
far they are-
land grabbing case cannot be
Attractive.
instituted against you.
Gosh.
Your second ground is that you are not anywhere inside their part of the land, and therefore no case can be instituted
Against-
against you. And
We are in rightful possession to our land, that is page 29, that is not known.
that we need not go into because the allegation is you are grabbing their land.
Because
So
adjoining land.
what-
Adjoining land, we have a adjoining.
Okay, you are
land.
in possession of the land,
Same village, my lord, only dark number, pattern number different, and
Hmm.
our measurement also different.
Hmm.
We have possessed, my lord, in separate
And-
patta, dark number 491 has created new patta 1087, page 29 I am reading, and new dark number 1314. There is an order, circle officer order. And on that ground, and on this land possession, we are in rightful possession to our land.
Hmm.
We never enter to their land. Why they
so
unnecessary?
point number 1 and point number 2 will be taken care of by the trial court. If we refuse to interfere in the matter. It will be taken care of by the trial court. Even if we entertain the petition, we will not declare who is sitting where or who is in possession of what or who is the owner of what. Done? Now you have to show us that in the absence of any criminal intimidation, land grabbing case cannot proceed. That is what you are trying to show us on the basis of
I
the
have-
Supreme Court judgment.
Yes.
Now, this Supreme Court judgment according to, yes, what do you have to say?
My lord has already read the paragraph number 6 at page 23 and 24, my lord. Already I have stated, my lord, they have attacked me with dao and sticks, my lord. And they have dispossessed me from the suit land, my lord. That is measuring 2
So you also say that in the absence of any criminal intimidation, there can be no case of land grabbing, but in your case, there is criminal intimidation.
It
Is that your submission?
No, my lord. They have tried to attack me, my lord, and they have illegally taken the possession of the land.
Huh.
my lord. That's what, my lord.
No, no,
And
we are not on facts, we are on, only on law.
My lord, and what they,
He says the law is in the absence of criminal intimidation, there will be no land grabbing case.
no, my lord.
Show us otherwise.
Otherwise, my lord, mere allegation that, my lord, they have dispossessed me from the land, Supreme Court has stated. my
That
lord.
is enough.
That is enough, my lord. Paragraph 53 and 54. my lord. '52 and 53, my lord. Submission of Mr. 53 is an averment that the appellant has been in unlawful possession itself is sufficient to invoke the provisions of the said act in view of the decision of this court in so and so. Keeping in view that fact that the appellant had no title and consequently could not acquire in title, all other contention raised on his behalf, in our opinion, pale into insignificance. The fact of the matter squarely covers the case. And in paragraph number 52, my lord, states that appellant illegally, forcibly, unscrupulously, and with criminal intention of grabbing the government land, enter upon the government. Here the land was government, my lord, but here it's a private land. That is the only difference.
Kindly clarify one thing. You were reading paragraph 6. You were reading paragraph 6. Now, it has two portions. It has two portions. A combined reading of clause D and E would suggest that to bring a person within the meaning of the expression land grabber, it must be shown that 1A. Done? Then on the next page, you will find 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from the below. Please count. The last word is or.
Or for construction.
Or. So just a minute. Huh? No. Not construction. 10th line from the below, the last word is or. Or license and lease on basis of construction or use and occupation of unauthorized structures. There is a semicolon.
Yes.
Then an or starts.
He has given.
So in two situations, that is either 1A or 2, 1 ABC or 2, you can be called a land grabber. Criminal intimidation is contained in subclause 2. Yes?
Yes.
So even if we find that something has happened under subclause 1, you would still be liable to be prosecuted. Let us not take it that way. Let us say the applicant would still be entitled to proceed in a case of land grabbing under section 1A, B, and C. Yes. So that criminal intimidation part, the argument on your,
If we taken illegal possession,
that is only.
then, because we denied, because so far.
So that will be decided, the assertion and denial will be decided by the learned trial court, not by the.
This court.
So
Question
therefore
is,
the
my lord,
criminal
whether-
petition is,
whether-
therefore the criminal
one
petition
thing
is.
Very important.
Ah,
We have stated here that we are in possession to our land.
that
We
will,
never
that,
enter. That is to be.
which district?
Because I have laid ground for quashing, my lord,
Ah.
privacy ownership established.
Beyond the river, that will be decided beyond the
Our-
river,
our
not on this side.
privacy ownership is established. So far, the page 29 is
Heard
concerned.
Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr.
A. Iqbal.
So-and-so, so-and-so. The respondents' arguments have been heard. Judgment reserved.
Lordship,
Yes,
1020 page 29.
Page
We have
29.
own land and we are in that position.
we'll
That
keep
is
that
the-
in. We'll keep that
And that
in.
is why this is the ground number second,
Ah,
privacy ownership established.
yes.
We are not jumping to other thing. Because we have sufficient.
All this, whether you are in their land or or on the land where you have established ownership, these are questions of trial, not of.
But this is to be taken into account.
Hmm?
When, but this submission may note, my lord.
Yes, we will note it. Why not?
Because,
Every submission will be
there is
noted, sir.
Sufficient ownership already here.
Every submission will be noted.
My lord, they make party in the land giving case. We are not in no way a position.
You have that
May
proof
third,
in the.
may third party may in position.
Obliged.
But we are not. But we are not. Highly obliged.
Item 20, yes. আইও, এইখন গুচাই দিছিলো যে,
Regular
ট্ৰেখন,
bail application, your lordship.
এইখন যে এনেকুৱা এখন থাকে যে, এইখন অকমান পাৰাই দিবচোন, এই এনেকে দিওঁতে দুখ পাইছো এতিয়া। এখন দুইখন থকা চাই দিলো।
I have filed a charge sheet copy through the additional affidavit, your lordship.
হা,
Yes, lordship. And the accused are arrested on 27th of August 2025, your lordship. But in this case, your lordship, 47 and 48 BNSX are not applicable. 48 is not applicable, your lordship.
is not applicable, very
Not
well.
comply,
Not complied, sorry.
yes. And
Where is that 47, 48?
I have annexed the arrest memo in Annexer 5, page 27.
Page 27,
Yes.
yes.
Muhammad Azad Khan, in this
Hmm.
case, your lordship,
Yes.
of the paragraph number 8, name, address, email ID, telephone, whomsoever to convey the arrest information is W2 transmitted.
Hmm.
But no any W2 message or no any notice under section 48 should be received by the relatives of the accused persons, your lordship. So
Who was that
comply.
who was that relative who was supposed to be served?
And your lordship, in this arrest memo, your lordship, there could not be we could not be find here receipt of the signature of the relatives of the accused person, your lordship. There the signature of the arrestee and witness, but no any signature from the relatives of the accused person. Page number 27,
Hmm.
Annexer 5.
Hmm.
And your
Where were you arrested?
25 8.
In Sri Bhumi. You were arrested in Sri Bhumi. And your permanent address is of Manipur.
Yes, lordship. The
So,
accused person one is from Assam.
huh?
Muhammad
but
Ali Ahmed, he is from Assam.
Two
Gujarat.
person, my lord. One is from Assam, one
One is
Manipur.
from Manipur.
My lord, this,
Just a minute. One arrow.
And your lordship, according to the Bihan Kumar judgment, your lordship,
Hmm.
according to the Bihan Kumar judgment, your lordship, kindly may allow for submit the Bihan Kumar judgment, your lordship. Of the last page, paragraph number 42.
Hmm.
Paragraph number 42.
You are Muhammad Azaz Khan and
And Ali Ahmed.
Ali Ahmed.
Yes, lordship. And the Bihan Kumar judgment, your lordship, on the last page, paragraph number 42. Paragraph number 42 of the last paragraph, your lordship. Hence, the requirement of the communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such their person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22 Clause 1 of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. Of the last paragraph.
Whom did you nominate, madam?
Lordship means relatives or
Who?
accused.
Whom did you nominate? They are required to serve notice upon a person whom you nominated. Did we hear you right, the Bihan Kumar? Please read that again.
Lordship,
Also to friends, relatives, and such other persons as may be disclosed or nominated by the arrested person.
Lordship,
Kindly show us a statement in your petition that you nominated so and so person that you disclosed so and so person and yet nothing was done.
Last line, Your Lordship. Hence the requirement of communicating the grounds of arrest in writing, Your Lordship, is not only to the arrested person, but also to the friends, relatives, or such other persons.
Very well agreed, madam. When no one is intimated,
Yes, Lordship. And Your Lordship,
now again let us read Bihan Kumar for once.
and
The last line,
yeah,
the last line, Bihan Kumar. Bihan Kumar, last line again take up. From hence.
yes, Lordship. Hence,
Hmm.
the requirement
Hmm.
of the communicating the grounds of arrest in writing is not only to the arrested person,
Hmm.
but
But-
also to the friends, relatives, or such other persons as may be disclosed.
We go slow there. As may be disclosed or nominated by the arrested person. So first the arrested person has to say, please inform so and so about my arrest. Then if the arresting officer fails, yes, 21 or 22(1) violated.
And
Please show us from your petition that you had mentioned Mr. So and so, Miss so and so to be the nominated person whom to be informed. That you gave their name and address or phone number that please inform this man.
yes, Lordship.
Show us the statement. We don't want any proof of it. We want a statement that I had asked them to inform my mother, my father, my brother, my cousin, my wife, my child, anybody.
Yes, Lordship.
And it was not done. Where is that statement? Show us that statement. We will go by 22(1). I will release it. I will release the person now itself.
I'm going through the bail application number 2813/2025, which is granted bail by this honorable court of the page number 32 of Annexure 6.
Yes.
The main paragraph is, Your Lordship.
Yes, that was not what the question that we are raising was not taken into account.
Lordship,
I want an answer to my question, madam.
yes,
Give
Lordship.
us that answer.
The
Add
answers-
to,
as
give us that
all
answer.
answers will be come through the bail application number 2813.
Yes, yes, show us.
25, order dated 17
Yes.
2025.
Mm.
Page number 32. Page number 32, paragraph number 5, Your Lordship.
Hmm.
The learned counsel for the petitioners has further submitted that the trial court has rejected the prayer for bail of the petitioners mainly on the grounds that on perusal of the case diary, one WT message was found whereby the said message was sent to Station House Office Thobal in Manipur requesting him to inform the family members of the arrestee.
Hmm.
And she submits that though the trial court held that there is a substantial compliance of Article 22, Clause 1 of the Constitution of India in this case, however, there is no material on record to show that in fact of the grounds of arrest were communicated to the family members, friends, nominated persons of the petitioner. And the paragraph number 6, Your Lordship. The arrest memo prepared by the arresting authority, only the signatures of the accused petitioners have been taken and it does not indicate anything that the said arrest memo were communicated to the family members, friends or nominated persons of the petitioners. Your Lordship.
Hmm.
Same thing, Your Lordship, I have annexed the
I-
arrest memo also.
We will repeat our question, madam. That question was not considered in that bill petition. We have raised a question. We want an answer to that question. If you can give it to us, well and good. If you cannot, we will allow you time. Show us who were the nominated friend, family members or relatives that were informed to the arresting of authority. Otherwise, if I say tomorrow that I am not naming anybody, whom will they inform? Ultimately, the paper will come not informed to anybody.
Not informed.
It is upon the arrested person to say, this is the man, inform him. You have informed me, thank you, inform him. He has to give a name. He has to give some detail that please inform that person. After arresting the person within that 24 hours where he has to be produced and 2 hours prior to that production, person has to go from Sribhumi to Manipur. Trace out all the relatives, find out who may be the appropriate person, give him a slip, saying that this man is arrested. Can that be that? Can that be reason? That cannot be the reasoning. You must say, I told him, inform my brother. My brother was not informed. That sentence is enough. We believe you. But where is that sentence? That my mother was not informed. I had asked them to inform my brother, he was not informed.
But the section 48 of the BNS Act is which says. your lordship-
Nominated by the accused person. So was the nomination.
But we could not find any nominated person also, lordship.
Then the arrested person did not give him a nomination. Whom will they inform?
Still no any notice has been received by the.
By the whom? If we say notice has to be given to relatives,
lordship.
then the mama will come to say that the chacha did not get the information. Relative not informed. There has to be one particular person who has to be informed, or one set of persons nominated by you, not by law, nominated by you. Please inform so and so.
Okay, lordship, kindly scan copy may be called for your lordship.
Huh?
The charge sheeted matters, scan copy may be called. I have filed.
Charge sheeted matters can copy may be called for. Yes, what do you say?
Yes, my lord, here, my lord, that was not the issue. Earlier, CD was called for.
Hmm.
Now we have come to, my lord, inform that charge sheet already filed
Hmm.
after the filing of this case.
Hmm.
Let them approach the trial court.
Would you like to try your hand at the trial? court?
Copy may be called for your lordship. This is the case of the court, your lordship, and.
Yes, take
yes,
down.
Scan copy.
Heard
may be-
Ms. So-and-so learned counsel appearing for the petitioner also heard Mr. So-and-so learned APP. Full stop. When the matter was taken up, the learned APP has submitted that he is under instructions that the charge sheet has already been submitted.
White CS number
Right, CS number so-and-so, so-and-so, so-and-so.
51/25 dated 31/10/25.
Full stop. Next para. Ms. So-and-so has submitted that there is a violation of the law laid down by the by the apex court in the case of Vihan Kumar versus State of Haryana and other, wherein there was a mandatory requirement for submitting notice to the for disclosing and communicating the grounds of arrest in writing not only to the arrested person, but also to friends, relatives, and such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest is rendered illegal. Full stop. On a pointed query by this court as to the identification of the disclosed or nominated person by the arrested person to whom the grounds were to be disclosed, comma, Ms. Medhi has submitted that since charge sheet has already been submitted, the scanned copy of the same may be called for accordingly.
Otherwise, they'll lose one forum, my lord. At this stage, they may approach, my lord, because, my lord, otherwise they lose one forum.
Advising outside the court.
Scan copy may be called for-
Accordingly, the scanned copy of the trial court records.
We don't know the number, we don't know the, my lord, special case
Lordship-
number, we don't know, my lord, at this stage.
Lordship,
Because
I have filed the charge sheet copy and PS case number is 47.
PS case number already
Like
there.
case number 47/2025, and I will be submit your lordship. Kindly give me 3 minutes.
Oh,
after
yes.
this matter, I will be submit
Yes.
the.
Have the number. Bring the number. TCR of special case number so and so. Huh?
Yes,
Bring the number, give it to her,
Okay,
we'll fill it up. But give it before 1 o'clock because we'll be signing the orders day after.
yes,
Huh?
lordship,
Bring it
kindly
before.
give-
1. Yes, next.
And your lordship, that may be fixed on 18/12, your lordship, kindly.
18/12,
Yes, lordship.
1812 is overburden, madam. It has to go on the first. New
21st,
Year. Happy New Year.
21st, 22.
Huh?
This will be come through the registry, your lordship. Kindly 18/12 maybe.
No, registry, it will come.
18/12, I will be go to out of station.
Then, my
Till
lord,
when?
21st or
Lordship,
22nd.
Another matter, your lordship.
Till when?
Another matter, date 20, after 20, I will be go to,
20 of December.
yes, lordship.
So we'll have it on the 6th of January.
6th of January is not possible,
Yeah.
Lordship. Kindly keep this matter on
Next.
19.
Next,
19 or 20 January.
20th of January. We were saying 6th of January. He's bringing it to 19th of
It's
January.
so much wrong that Lordship.
So therefore keep it at 6th. Yes, next.
Next, Lordship,
Miss
date
Medhi.
fixed your Lordship. Kindly.
Ms. Medhi, we,
In this
we are tolerant, but then the clock does not stop.
Kindly,
We
Lordship,
are waiting for the next case.
date may be fixed, your
Please
Lordship.
be kind for one occasion on us. You give the number, we'll call for the scan copy and we will fix the matter on the 6th of January where you can make further submissions. Yes.
My lord, with all respect, my lord, second
Yes.
application, my lord,
Yes.
only case diary, my lord, if possible.
Second application.
My lord, my lord.
Went wrong. Heard Mr. B.K. Mahajan, Learned Counsel appearing for the petitioner. Also heard Mr. So-and-so. Learned APP, comma. This is the second bill application referred by the petitioner, comma, call for the updated CD. Call for the updated CD. When do you want? When can we have it?
As your lordship directed,
Tell us a date at your convenience. Tell us a date.
from the court's calendar lordship, because
Huh? Huh?
only 1 week left.
Huh? 1 week is left, that is
Yes.
what. Can we have it immediately on the reopening?
As your lordship pleases.
एकदम immediate on the
6th
reopening को
January.
क्या দিব पड़े? हाँ हाँ.
Full out
After
discount.
we do it. Immediately did it. Sorry. 5th of
Highly
January,
obliged.
sir. Fifty-one. Yes,
Hearing the petitioner, he is in custody for 157 days.
100. Oh, why so
57 days.
long?
Basically, nothing was recovered from his possession and it was recovered from 3 persons, your lordship.
Hmm.
And the FIR disclosed that the lordship kindly have a look at page 10, your lordship.
Huh.
The Elise Ganja was recovered from 3 persons, your lordship.
Huh.
Page 10, your lordship kindly. see.
Yes, yes, we are having that.
From 1 person, Bapi Shah,
Bapi
it
Nobadas and
was 18.8 kg. And thereafter, the next one, Nobodash, it was 18.8 kg.
yes.
And the third one is 19.1 kg.
Huh.
So the ganja recovered from 3 different persons, your lordship, it was clapped together
Huh.
and attacked the section of commercial quantity.
Yes.
But the petitioner, your lordship, nothing he has been recovered and he was arrested after 2 days from the date of arrest of the other co-accused.
Why?
Basically, on the basis of the statement recorded, page 17, your lordship kindly have,
Eh?
page 17.
17 years.
This is the forwarding report of the petitioner, your lordship.
Hmm.
Page 70, investigation during police custody remand, your lordship.
Hmm. 22/7/2025. Yes, sir.
They may be having some more submission. also.
Huh?
And the other person, your lordship, person I have, today I have, that is one Rohim Ali, your lordship, who was the e-rickshaw driver. And he was released on bail by your lordship. Initially, it was interim was there on the ground of medical issue and subsequently it was made absolute by your lordship. In here, the only allegation is that the petitioner hired the person, but it was the statement made by the co-accused that they were hired by the petitioner. And on the basis of the statement of the other co-accused, the present petitioner, he has been
Hmm.
implicated.
What is the ground for bail, sir?
The ground of bail, your
Why
lordship,
should we release him?
the statement of the co-accused, your lordship, is not admissible at all.
Even for investigation.
No, even if it is not, if
Now it is
conviction.
investigation
No, no,
stage.
Yes, I'm not
Ah.
saying on that, but it is, my submission is that if conviction cannot be sustained on the basis of the statement.
Therefore, the
Then
investigation.
No, therefore, this is my submission, your lordship. If conviction cannot be, then I think that principle should be applied in here also. And apart from that, your lordship, other submission is that regarding clubbing, adding section 21 C, your lordship, because the contrabands were recovered from three different persons. 18 point something and 18 point something, 19 point something. All are less than commercial quantity.
18 kg is less than commercial
Yes.
quantity.
And to be, in case of Ganza, it will be the 20 kg.
20 kg, huh? So 18 kg, 18.7 kg and 19.1 kg. Hair's breadth, yes.
Yes,
Ah,
three
so-
different person, your lordship, it was recovered. And altogether, your lordship, it was 75.4 kg, your lordship.
Hmm.
That means that less than 20 kg, it will be the in between, your lordship.
Intermediate.
Yes. So my contention is that heading section, your lordship, 21 C, your lordship, is not appropriate, and
Those are all if and when the conviction comes. Tell us why the bail to a member of the organizing committee.
the organizing, your lordship, it will be revealed from the case diary, your lordship.
That is why
Whether
release you
is
now?
there any,
Why release you now when the people caught with the contraband are saying that we were carrying it for so and so person? So now they are investigating. Why at this stage is what we are trying to.
now, your lordship, apart from the statement of co-accused,
Nothing is there.
they have found any other materials
That
against
is
the
the-
present
that is-
petitioner, lordship?
That is.
Friend will submit thereof.
Yes.
Lordship, they have not made any submission with regard to section 37. That is my first.
37 is if the individual quantities are less.
No, Lordship, even then.
Can you club it up?
In a commercial quantity, Lordship, case, this is registered under commercial quantity, C is there.
Maybe, but when the individual,
For that, Lordship, 29 is also there.
huh,
Section 29 criminal conspiracy, they acted within the criminal conspiracy. So it is commercial quantity. So section 37 has to be complied with. They have not made any submission. Secondly, Lordship will see the three persons were traveling in the same train. They were recovered from they were arrested from the same compartment, B1. So Lordship, criminal conspiracy is there only, Lordship. Next, Lordship, regarding the materials with relation to the present petitioner. Before that, Lordship, one more co-accused, he is absconding. He has not been arrested so far. This petitioner, Lordship, and the other co-accused who was released on bail, he has only submitted that medical condition. Only because of that, so parity does not come. In relation to the present petitioner, Lordship, from the investigation so far, Lordship, the mobile phone has been sent for FSL. He was the one who arranged for the train tickets of these three persons. That is under investigation. He was in constant touch with the other three individuals, Lordship. That is also under investigation. FSL reports are awaited. And regarding the seized article, Lordship, already FSL report is received. It is ganja. So at this stage, Lordship, there is no ground. And Lordship, regarding Tufan Singh judgment, statement of the co-accused cannot be used. It is during the trial, Lordship.
During the trial,
Not investigation.
For if we stop it in the investigating process.
Yes,
it will be
so
okay.
at this stage,
Yes.
Lordship,
Regarding
at
conspiracy,
this stage, I'm not finished.
Yes,
At
sir.
this stage, Lordship, since the investigation is going on, commercial quantity, 180 days is the mandatory period. He has not satisfied your Lordship regarding 37, so this bill may be rejected at this stage, Lordship.
my friend, your lordship, relying basically that mobile phone, your lordship, and the forensic. But herein, to attack conspiracy, your lordship, there has to be a agreement, your lordship. We are sitting three person together, your lordship, it is not
To-
amount
To
to.
prove,
That is subject matter
to
of trial.
prove conspiracy, the agreement has to be proved. To investigate conspiracy, agreement has got nothing to do with it.
Therefore,
Sir,
only
they
I
are
am
the-
saying, your lordship, my friend has referred here, your lordship, mobile phone has been seized.
Yes.
If it is possible, your lordship, then the FSL report may be.
No,
of course,
Lordship.
your lordship.
I'm
And why
objecting
I'm
to that.
saying, your
I'm
lordship,
objecting to
We'll,
that.
we'll call
Otherwise-
it at a later stage.
So that cannot be a
Otherwise-
consideration for bail, Lordship. This has
We
come
will,
up for
we will,
disposal,
we will
Lordship.
call it at a later stage when the FSL report is
Yes,
available.
But
Anything
the-
else,
the
sir?
Tufan Singh
Why are
judgment,
two
your lordship,
petitions
this
for-
can be,
দুটা কেলে? There are two petitions.
no, no, no.
এখন কি হয়েছে? কি ধরলুম আমরা?
One more submission is in here, your lordship, since this is not a criminal petition, your lordship. Clubbing, your lordship, adding section, that part, your lordship also can consider. And the second part is that, your lordship, my friend has submitted that the conspiracy is there. Mere statement is not sufficient. They have to prove it. Now proving, they are relying that the mobile phone has been seized and it is sent to the forensic, but no report they have yet collected. So therefore only I am saying, your lordship, The forensic report.
When were you arrested?
Lordship, regarding that, my submission is, Lordship,
22, Your Lordship, 22
Without-
July 2024.
without
That's
going
the
into the
25.
FSL report of the mobile phone, Lordship, has he made any submission with regard to section 37?
No, no,
He has to-
37,
Let me
Yes,
finish.
yes.
He has to first and foremost satisfy your Lordship regarding the section 37, that he is not associated with the crime, that he will not repeat the crime in a commercial
Yes.
quantity case. Let him submit on that, Lordship.
Take down.
I am only praying, Your Lordship, for FSL report. Your Lordship. Because the whole, then,
Not at this stage, sir.
otherwise, Your
Mr.
Lordship,
A.M. Khan, Learned Counsel appearing for the people, huh?
otherwise, Your Lordship, regarding, in case of regular bail, Your
He is
Lordship. the-
behind bars right now. He is behind bars right now.
Yes.
We'll call for the FSL, it will take some more time. So during this more time, let there be no pendency of the case, so that once that time is gone, you can come back
No, no,
and we
I
can
think-
look at it
I
afresh
just want
with
to
better
minimize
mind.
the burden of the court, Your Lordship.
Huh?
If Your Lordship will pass some order, then
Only-
again again he will,
Sorry?
if Your Lordship will pass order today,
Hmm.
then again he will have to approach before other from Your Lordship. So therefore only I am saying, keep it pending, Your Lordship.
Is that a threat?
No, no, no,
Do we understand that to be a threat?
no, no, no. I am only submitting, Your Lordship, that just for calling the FSL, Your Lordship. It will be.
Yes,
easy.
take down. Heard Mr. Khan, Learned Counsel appearing for the applicant, also heard Mr. Sharma, Learned Counsel appearing for the, appearing as the additional public prosecutor. Full stop. This bill petition had been filed under section 483 of the BNSS, praying for bail in connection with Bongaigaon GRPS case number so-and-so under so-and-so page one huh? Wherein the petitioner herein has been under under detention from 22/7/2025. The Learned Counsel for the petitioner has submitted that the petitioner is aged about 22 years and he is not a named accused in the FIR dated 19/7/2025. The Learned Counsel for the petitioner has submitted that 3 persons had been named in the said FIR where some alleged contrabands, below the commercial quantity in respect of each of the named accused had been recovered from a certain train, a certain bogie of a train. Full stop. The Learned Counsel for the petitioner has submitted that it is only on the basis of the 3 persons so arrested, that the petitioner in the present writ petition has also been taken into custody by the police authorities on 22/7/2025. Full stop. The Learned Counsel for the petitioner has submitted that taken individually, even if the allegation of the investigating authority is taken on the face value, none of the recovery is of commercial quantity, but are of intermediate quantity only. The Learned Counsel for the petitioner further submits that mere assumption of a conspiracy would not be ground enough for the continued prolonged detention of the applicant herein. And what else was the submission?
Co-accused statement.
Huh?
One of the co-accused has already been released.
The Learned Counsel for the petitioner has submitted that one of the co-accused has already been released on bail by this court. And therefore, it cannot be the case of the investigating authority that release of the petitioner now would hamper or temper the investigation in any manner. Yes. Any more submissions, sir? No.
Tufan Singh, that is also missed.
Huh?
Tufan Singh judgment, your lordship, that means the statement of the
Ha.
co-accused
The
recorded.
learned counsel for the petitioner has also submitted that in view of the judgment of the apex court in Tufan Singh, reported as so and so, comma, the statement of the co-accused cannot be used against another accused to prove the guilt
Yes. To prove.
of the accused.
Inadmissible in evidence.
Are inadmissible in evidence, full stop. Yes. Anything more? Anything more, sir? Any other submission to be recorded? The learned additional public prosecutor has submitted that the investigation is yet at an initial stage since one of the co-accused is absconding arrest and is yet to be apprehended. Full stop. He has further submitted that as per the updated case diary received, all the three co-accused who were arrested from the train were
Traveling in the same.
traveling in the same bogie. And there are indications to show that the petitioner was involved in arranging for the
Pen-
travel of the said persons, full stop. With regard to the person who has already been released on bail, comma, the learned APP has submitted that same was done only under the consideration that the said person required urgent medical attention, and it was not on the basis of the uh, medical, urgent medical attention, full stop. The learned additional public prosecutor has further submitted that yes,
FSL has been
the
received.
FSL, the mobile phones and other
Yes.
materials have been sent for the forensic laboratory tests and the results are awaited.
Awaited, yet
Full
to be.
stop. He has submitted that
And regarding the,
since the,
regarding the psychotropic substances, lordship, that FSL has been received, it is ganja, lordship.
he has however submitted that the substances have been confirmed to be ganja as per the FSL report.
8825.
Huh?
8825.
We are not going to that. The learned counsel, the learned APP has further submitted that the petitioner has not asserted or argued on the provisions of section 37 of the NDPS Act, and therefore this bail petition does not deserve to be considered at this stage, comma, since the investigation is still going on and it is apprehended that the petitioner herein was arranging for the logistics for carrying of contraband substances, full
As
stop.
well as financing, lordship.
And as well as
Financing the.
it is also suspected that investigations may reveal the involvement of the applicant or otherwise in financing the trade of contraband substances, full stop. We have considered the submissions made by the learned counsel for the contesting parties, full stop. We have also gone through the materials placed before us, full stop. Although the learned counsel for the petitioner has requested that the matter may be kept pending awaiting the final FSL reports, this court is of the view that at the present stage, which indicates an initial phase of the investigation and also keeping in view the fact that there are materials enough against the petitioner herein, this court does not consider it to be a fit case to be granted the privilege of a regular bail at this stage. Accordingly, this bail petition is rejected at this stage. Full stop. This will not preclude the petitioner from approaching the appropriate forum again with prayer for bail after the investigation has proceeded to a certain extent. bail petition rejected.
Return the CD, Lordship.
Hmm?
We'll return the CD.
The learned APP is permitted to return the CD to the investigating authority. Yes, yes, madam, you found it out.
Yes, case number is 106/2025.
এই আগৰ কেছটোত probably আপুনি ললে নে কোনোবা ললে blank এটা থাকি গল নহয় NDP call for the
Scan copy.
of the of
NDPS.
NDPS case number
Call for the TCR, the trial court record of
or trial court will call for the
the TCR, trial court
TCR.
records.
Okay, Lordship.
or the whole of it.
Yes, Lordship, the CD part also has to be there, Lordship,
Huh.
along with the court's order, Lordship, after.
Trial court's record don't come, the scan copy comes.
Yes,
Lordship.
Scan copy of the trial court records
scan copy of the trial.
in connection with NDPS case number. No, we were under the impression you are asking us to call for the trial court records. That will be as good as staying the entire proceeding day.
And that
That
may
is
be
why
fixed
we were
on-
surprised.
Humble request, Your Lordship, that will be
Yes.
fixed on 5, Your Lordship, because 6, I will be go to outside, Your Lordship.
No, we
Another
can have
day.
it on the 5th. On
5, Lordship.
the 5th of July, সেইটো date to 5th of January কৰি দিব madam matter to. Huh? File to second order to মাৰিব to 5th of July, 5th of January কৰি.
Obliged, Lordship.
Yes, huh?
I'd like to mention item number 25, Lordship. I have filed the additional affidavit
Huh?
as per the last order, Lordship.
Huh?
So as per the office note, the additional affidavit not on record, Lordship.
Huh?
Maybe call for that,
Oh, yes,
Lordship.
please. আনিব পাৰিব নে additional affidavit এখন? Additional affidavit এখন অনাই লগাই দিব লাগে কোনোবা এটা item ত লগাই।
Obliged.
Thank you. Failed to prove the charges under section 4 of the POCSO Act beyond reasonable doubt. Accordingly, the orders are set aside. Accused appellant be set at liberty forthwith unless wanted in connection with any other case. Send back the LCR.
Highly obliged.
ইয়াক কওকচোন পেঞ্চিল কেইডাল অকণমান জমা কৰি দিব
Please, Lord. 483 bail application.
Huh?
483 bail application, my lord.
PDP
Because we
POCSO
had
is there, so
serviced.
service lordship, I have communicated with the police concern lordship.
Hmm.
They have informed us risking today's time lordship. Service is not completed yet,
Monday or Tuesday?
Tuesday.
Tuesday, because we'll have to appoint an amicus also, if
Lordship.
none appears, yes?
My lord, already been 2 days taken by the prosecution.
I understand, but we have also to look into the fact that the police are now doing the job of a post office.
My lord.
Double burden. 2 days
But
time
the
more.
Case is also very,
Huh?
very significant, yes, if you, lordship, grant you the footage.
What happened? Tell us if,
FIR, I will look on FIR.
if anything we can do without the respondent number 2 appearing, we'll listen to you, yes? Can it be done? Can we pass any orders in absence of a representation by the respondent number 2 in a POCSO matter? Perhaps not. So we'll wait till Tuesday?
My lord.
TCR already received lordship.
TCI is received on Tuesday, we can have it.
Lordship.
Service report. No, learned APP has sought for some time to have instructions on the service report. Full stop. Let's this matter again on Monday, Tuesday, Wednesday, দিনাখন অকমান জাগা আছে। 16th.
May I please, your lordship?
TCR received?
Yes, my lord.
How is it?
According to the columnist receipt.
Hmm.
My lord, page 9 is the FIR. Translated portion, my lord. Short FIR, I am to read, my lord.
Hmm.
Respectfully begs to state that on 5/9/25 at around 9:30 AM from Un house at Nun Duinong, Nizorapar, my
Ah.
daughter namely so-and-so went to the school, but our said daughter till moment not returned
Yes.
to the home. At
Then-
present also not getting any information about said daughter, therefore request to you, sir, kindly rescue my daughter. After this, my lord, FIR was initially registered, my lord, section 87.
Ah.
DNS, which deals about the, my lord, kidnapping, abducting. And during the pendency, during the investigation of this case, my lord, by based on the victim statement recorded under section 183 by magistrate, my lord, section 6 of POCSO and section 65 subsection 1 added, my lord, in this case. Now, my lord, trial commence, and during trial, my lord, copy served to the accused person, and after that, I get the victim statement recorded under section 183 state. And after getting that, I have filed additional affidavit, my lord, with this bail application. Kindly peruse the, my lord, page 37. Where
Page
I have
30?
added the victim statement.
Page 30?
Page 37.
Yes.
My lord, I want to read out, my lord, subject to lordship permission.
Hmm.
My name and address are true as mentioned above. I have introduced with a boy, namely Arif Zaman, while he sometime used to visit his uncle's house. By that way, I meet with him because his uncle's house is located at near my house. After a few talks
Statement.
at Instagram,
Rashid has been submitted longer lordship and cognizance was taken on 14/10/25.
Hmm.
And he is in custody, and so far my instruction is that lordship, till now no witnesses have been examined.
Okay.
Charge framed on 30/10/25
Hmm.
under section 20B, subsection 2 and comma C also there.
Hmm.
8 numbers of plastic bag, 41.048 kg ganja recovered from the house of the petitioner.
How much?
41.048 kg.
It was
It was
recovered.
Net weight of the suspected ganja, 41.04 yes.
Marshal quantity.
Then your, this other part is wrong. 4948 kg. How do you say that?
Lordship, these are all bags,
Five,
lordship,
zero.
8 bags. and
8 numbers
total
of plastic bags.
Each bag is containing how much? 4948 kg. Where is the dot? There is no point, you see.
Yes, I have also
4948
listened,
kg.
but I have checked the order.
5000 kgs.
41,000 kg was no dot was there.
Huh? From August.
Lordship, if lordship will come to the FIR as well as the forwarding report, lordship. The forwarding
tonight.
report shows that
Ship concern.
at that time he was not in the house, lordship.
Hmm?
He was not present in the house.
Hmm.
But so far my instruction is that it was not seized from his dwelling house, lordship.
From whose? Brothers?
No, it was from another house adjacent to the
Adjacent to. That will be a matter of trial.
right.
Well, there are 6 PWs in the. They have been the prosecution witness lordship. No witnesses examined yet. Also, let the PWs be examined lordship. At this stage of investigation, this was charged from 30/10/2025.
Huh?
This is the initial stage of trial lordship.
Yeah.
30/10/25.
Lordship will examine, lordship, this, initially in these cases, lordship, Caesar witnesses are examined, lordship. So
Ah.
it is already
Oh.
fixed on, as my friend has submitted that is fixed, fixed of.
KTR is fixed. When is it
5/1,
fixed?
lordship.
Huh?
5/1,
5-1. We'll have it on 21.
21/1.
Let some of the witnesses be examined. Heard Mr. So-and-so Leonard Counsel appearing for the petitioner, also heard Leonard Goswami appearing for the, as the APP, full stop. It has been submitted that the next date in the trial court has been fixed on 5/1/2026 for examination of PWs, full stop. Let this matter be listed on 20/1/2026.
Updated.
In the meantime, the updated status of the trial court and along with the statements of the witnesses recorded, if any, be procured. Yes.
25.
Yes.
Now it's a charge sheeted matter, Lordship. I have filed additional affidavit to bring the charge sheet, Lordship.
Hmm.
on record.
What do you want to do? Press it here or
Lordship,
press it here or take a chance there?
Better to take a chance there, Lordship. It's a commercial quantity on there.
45 years. Recovery is how much?
recovery is, Lordship, 672 is pass tablet, Lordship, and 490 natrizapam tablet from the
Hmm.
petitioner's, Lordship.
Also some cash.
Also some case.
You'd like to try it there? We'll give you the liberty.
Lordship, actually, Lordship, in this case, Lordship, 47, 48 violation is there, Lordship.
Show us.
It starts from page 33.
Agree.
Lordship. The written as ground of arrest, but
Hmm.
these are reasons for arrest, Lordship.
Page number?
This number starts from 33, Lordship. 47 and 48 both, Lordship.
Ha. What more do you need? After
Yes.
paragraph 3, what more do you need?
In paragraph,
After
Must
the
cause of
third
effect.
reason oblique grounds, what do you need?
in this case, Lordship,
During the raid of your house, you were detained in red-handed along with the narcotic substances.
What more to do?
What more ground do you need?
but what are the seized articles not been mentioned,
Huh?
not mentioned in the 47 and 48 notices, Lordship.
With narcotic substances and contraband mentioned. What more?
But what is the contraband not mentioned, Lordship?
Huh?
That is to be there, Lordship, the basic facts. As per
What was recovered?
From
I
his
think
person,
the
it is
Supreme
recovered.
Court also says that the entire history does not have to be given to you.
But
Huh?
the basic allegation, that means what is the contraband to be mentioned, Lordship?
Either you show us something more or you take a chance there.
And more,
LS
Lordship,
47 there.
Lordship, and both are husband and wife, Lordship, and they have children. One boy is 9 years, and one girl is 13 years, Lordship. And for the welfare of the child may be considered, Lordship.
And he is welfare, for the welfare of the society.
No, for the, if there are two children, both husband and wife inside. Huh?
It's my humble prayer, Lordship. Any condition, Lordship, may be given. And also, I don't have the parents also, they are already died, Lordship.
Let them approach to before trial court, Lordship.
We'll record your submissions.
Okay.
Make an observation that you have two children.
Lordship.
And in case of your approach, the same would be kept in mind while dealing with the necessity of your further custody. Will do. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. Goswami learned APP, full stop. This is a case under 438, 483 of the BNSS, praying for grant of bail to the two petitioners who are related as husband and wife and have been in judicial custody since 12/8/2025 in connection with Goripur PS case number so-and-so, full stop. The learned counsel for the petitioner has submitted that the charge sheet in the case has been submitted recently after filing of this bail petition, and the same has been brought on record by way of an additional affidavit, full stop. In view of the aforesaid facts and circumstances, this court is of the opinion that the petitioner be allowed the liberty to approach the learned trial court with appropriate petition seeking bail, comma, of a full stop. The Learned Trial Court on receipt of the said application shall take into consideration the fact that both the petitioners who are related as husband and wife have minor children of 9 years and 13 years
13 years.
respectively, as stated by the learned counsel for the petitioner, and the same shall be considered at the time when the bail application is preferred by the petitioners before the learned trial court, bail application accordingly disposed of.
As per law, Lordship.
As per law, shall be considered as per law.
God bless you.
26.
Yes,
Recovery of 183 grams fine. 184 grams fine. This is an intermediate one. We don't mind from 3 persons minor. And it was not specific from which it was recovered. And ultimately such it was submitted. That was also, it was submitted on
31/10/20.
2025.
31 charges submitted. What is the stage now?
This, 7 PW.
We approached the court below on, it was rejected on 3/11. So considering the fact that it is a spring section, bar on the section 37 is not applicable.
Huh?
And already he is in custody. So my release shall not cause any. Because of to the trial court matter. That will be-
As per TCR, last date was 17/11/25.
Hmm. No witnesses examined till now.
Now,
Charges
charge is not framed yet.
Charges not framed.
Since it is a quantity is intermediate quantity. So I-
Intermediate quantity recovered from 3%.
3%. 180 total, without soap boxes, 184 grams.
184 grams, 3%.
3%.
3%.
As per their statement, they have collected the contraband from a drug dealer named Sadiq Ahmed.
Hmm. Sadiq Ahmed,
That is not reflected in the TCR, the way he is detained under custody or not. That is, we have not.
it is not
It
there.
is not been submitted.
He has not been charged sheeted in this case now.
No such reason.
Yes, what do you say?
Release at this way. So then they properly.
Custodial, why in custody during the trial now? Huh?
That I agree with you, Lordship, by objection may be recorded in this regard.
No, objections will always be recorded. There is nothing short of it, but he- 25, 44. Recovered from body.
Yes,
Body,
they have
personal, body size match.
fully tapped with the bags, packets.
If he's trying to sell, why will he tape it to his body? It will be so difficult to remove it and sell. Logic defies. Any case, 24-year-old, 50-year-old. You can consider for this for this applicant number 2.
And one also got an injury minor in the jail also.
Hmm?
One of the accused minor,
Hmm.
that is Nazarul Hope, was admitted in the jail hospital.
He was admitted.
Yes, correct. He got an injury in a parietal region, extremely injury, undergoing treatment also. And the order itself.
That is okay.
So I pray my lord considering because since it is not a commercial crime, the detail is something. So we will face the trial, any strict condition may be imposed, man. This is the trial.
Charge framing stage, that is what we are.
Charge not framed yet, Lordship.
That is what, not yet.
Charge is only submitted on.
Charge is,
Ready to cooperate, but that we will not be away from justice. Stringent condition may be imposed.
intermediate.
That's my preamble.
Intermediate quantity, I think we'll allow it. Allow it. কৰি দিব এই 1811 লিখা আছে bid application under so and so so and so. Scan copy of the trial court record has been maybe received. The quantity involved is an intermediate quantity, therefore the regards of 37 would not be applicable. Investigation complete, charge sheet has been submitted. Huh? And view of the above, this court is of the opinion that the bail can be granted. 20,000, two sureties of the like amount.
Special Judge Kasar Silchar.
Special Judge Kachar Silchar. Baki condition kita dibo and shall not involve in, shall not involve in any criminal activity during the period of this bill. Huh?
And shall appear on each and every day before.
Hmm?
He shall appear.
That will all be there. He will not be involved in any criminal activity.
Yes.
Is what you have added. This poster?
27, Lordship may kindly pass over the time.
Pass over that timing, photo thaki bol. Yes.
Charge sheet submitted in discussion.
Charge sheet has been submitted, madam.
Lordship, let me see her tomorrow, Lordship.
Tomorrow at this hour, if we send the files, it becomes very difficult for everybody. Have an instruction since the charge sheet has been submitted, whether you would go and have an instruction, we'll take it up after some time. If you can have the instruction, if you can approach the trial court better. If we need to decide it, we'll decide it. All of you, Mati.
Same prayer, Lordship, charge sheet submitted in discussion.
May I please, Your Lordship? Even I am well aware that charge sheet has been submitted in. But there are certain anomalies, you know, I would like
please.
to bring in light.
Hmm.
May I please, Your Lordship, the FIR is at page number 9. Operative portion is page number 12, Your Lordship. Second paragraph of the FIR. At 11:15 AM, I along with my accompanied staff party arrived at Sadarsi area. At the meantime, so and so, my police team arrived at the spot. On reaching the area, I set up a Naka checking. After some time, the targeting vehicle arrived and I was detained. Now this happened at 11:15 to between 12 o'clock. Time has not been specifically mentioned. Why I'm raising this issue is, Your Lordships, there are anomalies in the date and time. If section 47 notice be perused, which is in the additional affidavit, page number 39. In that notice, Your Lordships, the date of arrest has been mentioned as 18/6/2025. But in the FIR, date of arrest is 17/6/2024. Time in the FIR is 11:30 approximately, because it has not been mentioned very cunningly, Your Lordship. But in section 47, Your Lordship,
Let
the
us-
time of arrest,
Do not use those terms.
I seek apology.
Do not use those terms.
Okay,
Yes.
really seek. But in the section 47 notice, the date of arrest is 18 and the time is 12:30. Place of detention is Karimganj police station. But according to FIR, I have been detained at the spot, which is Sadarasi area. I have been arrested therein.
Is there a difference between detention and arrest? Or there is no difference?
Your Lordship, as per the NDPS Act, when a person has been stopped and some substances are found, immediately authority letter has to be issued under section 41, 42 or 43. Thereafter, search has to be done by himself, body search, in presence of independent witnesses. Then body search of the person or the conveyance has to be searched. Then section 50 notice has to be issued. I accept that this might take a time. But what I'm trying to establish here is that after detaining me, they have not issued me they have not given me the chance to inform my family relative under section 36. Section 36 was also issued to me notice in the police station. My family member were not given a chance to know that I am being arrested. They were searching me. So more than 24 hours, I was illegally detained in the police station, because in the 36 notice, 47 notice, time of arrest is 12:30, 18/6.
There is little confusion, Your Lordship. That is the thing I'm trying to establish here. They have shown 18/6 as the date of arrest. Time is 12:30, but I have been arrested 1 day prior. And I have been produced before the court at 3:30, which is very much prima facie there in the FIR, Your Lordship, page number 9. At the very top, it has been very clearly mentioned there that 18/6, 3:30 PM. This part, Your Lordship, at the top of the FIR. There is the time where the police has produced the person, accused person, before the learned magistrate.
Page?
Page 9 of the main petition.
18/6, 26, 18/6, 3:33 PM. That is what you're showing us, 3:33 PM.
Yes, 3:33 PM.
Huh.
That's 18/6.
Hmm.
But as per the FIR, I have been arrested and brought to the police station on 17th itself, around 2:45 PM. After bringing me to the police station also at 2:45 PM, even if I consider what was police doing to me. My arrest memo was not issued. There is no witness signature in the arrest memo as per section 36 of the BNSS.
Mr. Goswami,
There is
the 24 hours part is what he's trying to
Yes.
emphasize. Now, if we have a look at page 24. At page 24,
For forwarding.
this is of 18/6. Brief fact of the case. Now at 17/6/25 at 8:15, he has lodged a written FIR.
Lordship.
So 8:15 is the written FIR. That at 10:45 something happened, 11:15 complainant went, came back, seized, and hence the case. So firstly, the arrest is prior to the written FIR.
Written FIR.
Number two, even if he has been arrested at 2:45, 2:45 you showed us somewhere, right?
Yes, Your Lordship, in the last page of the FIR. Last paragraph, at 17/6 at 2:45. Apprehended person were also kept at Karimganj PS for safe custody.
Where is it?
Last line, page 13, Lordship.
Page 13.
After completion of all formalities.
All formalities, I along with staff apprehended person and seized articles departed from the place of occurrence at 2:20. So apprehended persons were also kept at the Karimganj police station for safe custody from 2:45 onwards. And the production before the magistrate is at 3:33 PM. So you may have reached early, but the magistrate may have been taking up some other work.
May I please, distance also only 300 meters, Karimganj.
No, we understand, but he may be waiting for production at the door and the magistrate may be taking up some other matters. So that half an hour.
May I please, Your Lordship? First, police takes them to the PI court. All the entries are being made there. Then there may take time. Because magistrate may be very busy with other accused persons or whatsoever. the
Okay,
case.
so you produced him in the PI court at 3:33 PM is what he's saying. That is 45 minutes after 24 hours. How does it affect the bail part?
In a bail.
In a bail petition, how does it affect it?
It's a procedural, purely procedural lapse.
I have little more, Your Lordship. It will give
Yes,
me some
go ahead,
time.
go ahead. Go
Your
ahead.
Lordship, on 8/12/2025,
Huh?
they have filed a petition. I mean, the investigating agency has filed a petition before the learned court below for extension of the time of investigation. Now, it is 180 days as per NDPS Act, and my quantity is commercial, I admit that. Now, coming to the point, if please give these two documents are little delay. They are on the way from the post office, haven't reached me. I couldn't annex it to the affidavit. Your Lordship. This is the certified copy, Your Lordship. The third paragraph, first page. It is stated in the petition that the statutory period of investigation shall expire on 13/12.
Hmm.
but the investigation could not be completed within the statutory period. Taking you to the next page, your lordship, it is in the
This
last
is-
page, your lordship, last.
This is a copy you had obtained.
Yes, your lordship.
And why in a certified copy, why are you putting pen marks?
I see, apology again, your lordship.
You have totally finished the certification of this order. The moment you put a scratch on it, it goes, it is no longer a certified copy.
Thank you, your lordship.
Never put that, never call it.
So the-
18, yes, what were you saying?
The
After?
last page of this order, it is clearly mentioned. On careful perusal of the case diary, I find that it is not in proper order in respect of pagination.
Hmm.
First point. Second point, it appears that the investigating officer has not properly utilized the period already she got for investigating the case.
Hmm.
Third point, it appears that after entry dated 28/2025, that is August, the next entry in the case diary is 2010, that is October. The case diary also does not specifically reveal the steps taken for the apprehension of accused person so and so.
Yes, sir.
My humble prayer, interim. I am ready to face trial because charge sheet has already been submitted.
There is no entry in the case diary. Delay is deliberate. Huh?
It's a record from the call post.
Commercial
No,
quantity.
should we disbelieve the order of the trial court?
Absolutely not.
We will disbelieve the
No,
session
no,
judge.
no. Lordship, we are not submitting that. Lordship, the thing is, the IO has not taken steps in regard to investigation.
Hmm.
But that does not give him a right to be released on bail. Because NDPS commercial quantity, it is subjected to section 37. Whatever may be the reason, Lordship will have to be satisfied of 37, Lordship.
Hmm.
In any bail concerning commercial quantity. So this does not dilute the fact that this is a commercial quantity and the rigors of section 37 will always be there.
May I please, Your Lordship, 37 embargo is there.
Yes. Whether the IO has done his job, that is another aspect, Lordship. That may be taken care of by any other.
It is not about the IO doing the job. What we are concerned is if the delay is in the investigation all throughout.
Yes. Because,
Does it automatically mean that he'll remain behind bars till?
yes, Lordship will kindly take up section 37, just for a
The
moment.
rigors are there, we understand.
Every bail concerning commercial quantity, section 37 will apply. That is the basic thing. Lordship.
Hmm?
Okay, may I read? Notwithstanding anything contained in the Code of Criminal Procedure, every offence punishable under this Act shall be cognizable. No person accused of an offence punishable for offence under section 19, 24 or 27A and also for offences involving commercial quantity
Hmm.
shall be released on bail or on his own bond unless, number one, the PP has been given an opportunity so and so. Number two, where the PP opposes the application, the court is satisfied there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail.
Okay.
So that two conditions.
So
has to be there.
this was confiscated from you where?
Your Lordship, as per the FIR in nearby Sadarashi area GP office,
From your person?
from a bike which I was riding, it was my friend's bike. And as per the FIR, it is in a bag.
Which is on your bike?
Bag, as per
Which-
the FIR, hanging in my bike. Why I'm saying again and again as per the FIR, because I believe the investigation is faulty, number one. And number two, Your Lordship,
That will give you a right to have a acquittal, yes.
37 embargo is there. Number one,
So 30, argue on 37 that it was not.
learned public prosecutor should oppose, which is being very well done here. And number two, your Lordship should be satisfied that he is not guilty. Why he is not guilty, I'm saying, Your Lordship, because the investigation is faulty. There is a matter of trial, Your Lordship, I believe.
Investigation faulty is not something.
I may be given a chance, Your Lordship. I just.
Charge sheet has been submitted.
Indeed.
And now you have to show us that Because under 37, if we give you the bail right now, it will be a presumption that you are not guilty. Charges have not been framed. No, after charges, after framing of charges or the first,
Your Lordship, I also have the copy of the charge sheet.
you have it. We also have it, luckily.
Your Lordship, that will not give a presumption to the entire precedent that I'm not guilty. But that will give a precedent that I've been given a chance to appear before the court, including my freedom. Because my wife is also sick, Your Lordship.
You come back after the charges are framed and the first few witnesses are taken up.
Your Lordship, a date may be given. I will like to satisfy this court with the precedents of the Honorable Supreme Court. There are many cases due to time bound. I've not been able to print out all the cases.
Okay, we'll do it. When do you want it? Look at it. Not in the
Monday.
next week, not in the next week. Next week, we are
At your
requested not to
convenience, Your Lordship.
fix up matters, huh?
At your convenience, Your Lordship.
So have it immediately on the reopening window, so any day in reopening.
Reopening
Seven.
of the court after the
6, 7, 8, 9,
7, Your Lordship.
7th. At the request of the learned counsel, paying for the petitioner, list this matter again on the 7th of January 2026.
Deeply obliged.
Argument to.
I being item 27.
Yes, sir.
They're not good.
Uh-huh.
I'm another crime story.
Ah, it's okay, yes.
Well, what happened, my lord, in the instant case, my lord?
Hmm.
Your lordship kindly read the FIR. I should not read the FIR because victim name is there, no, LS victim there. Lordship kindly read the FIR. Page, annexure 1, page 40. May I read, my lord?
I'm reading,
Yes, ma'am.
just give me some time. Yes.
Thereafter, your lordship kindly come to the forwarding report.
Hmm?
Forwarding report, annexure 2, my lord. Page 21, my lord.
Page 21, yes, sir.
Yes, my lord.
Hmm.
Lordship, in the forwarding report, my lord, I was arrested, my lord, and my lord, I was forwarded to the judicial custody. There is, my lord, there is no penetration and other part is not there. This only touching the body, my lord.
Proved with.
My lord, one important thing, page 26, my lord, I want to show, my lord. I don't know, my lord, why doctor has done these things, my lord. Because she is a minor girl, my lord. During the visitor period.
All the dates you are filling up by fixing the
What
cases.
happened when the victim girl was examined, bail will be granted, madam. How will it be? I can give many children, madam.
24.
Only thing is that he's a teacher.
8th? 8th আছে না জায়গা অলপমান? 8 তাৰিখে বৃহস্পতিবাৰ আছে? We'll have it on 8th, Mr. Chaudhary.
Yes, ma'am.
It has been submitted at the bar that the trial court has fixed 24th of December 20254, recording of evidence of the victim, full stop. Let this matter be listed on the 8th of January 2026 along with an updated
TCR.
updated TCR and the statement of the victim recorded if any. Copy of the statement of the victim.
Accommodation. I have talked to my referred advocate. He says he will talk to the lawyer when a client wanted. So next week, any day or after vacation.
We'll have it after vacation,
Yes.
but
Yes,
what-
the charge sheet I come to know.
Oh.
But what happened, DRPF has arrested him. He was traveling in a train up to Silchar. Then under his seat, a bag was found. Sari, wrapped with some contraband goods.
Oh.
That he suspected, very strong suspicion that there are so many passengers in the train, all were brought down. He also got down, then said that his bag, then said it is, because it was under his seat, he was sleeping, it is his bag.
a unique case where while sleeping bags are taken away. This is
Yes.
one case where while sleeping bags is given to him. We'll
Probably.
have it immediately on the reopening, sir.
And
Immediately.
but my lord, GRP have not followed the 47, 48, and 37 of the BNSS newly.
Ah.
Well, I have seen this. There is a mandate. State government must have a room, control room, where ASI is to be deputed. He is to maintain all the action taken by the 47, 48. And we have to meet the
48, that
APM
is,
also.
that is what we had a discussion in the morning.
Yes.
This is out of this thing, but morning we had a discussion. When there is no allegation or when there is no assertion that the accused has given the name of so-and-so person,
Yes.
nominated him to be the friend or relative to whom information should be given, what can the arresting authority do? He
That's why-
refuses to name anybody. I will not give you the name. And then he comes to the court and says, no one has been informed.
But when it is being mandatory, but in Assam, still today it has not been done. Nowhere, no police station is having this arrangement.
There is an
That
appropriate
is a special protection for the accused.
there is an appropriate forum survey which can enforce these things.
Can decree, my lord.
Huh?
Your lordship also pass an order on this point.
It will put us to a big problem. I'll list this matter again on 8th
7th of January, when it is possible.
8th, if it is 9th.
My lord, what I am saying, my lord, kindly say for 40, obligation of person making arrest to inform about his arrest, etc. Every police officer or other person making any arrest of this Sanghita shall forthwith to the inform regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other person as may be disclosed or nominated by the arrested.
Yes, that is what we are on.
Of giving such info. If
That
I
part-
don't nominate also, then what will be the consequences?
We don't know. Disclosure nomination has to be done by the arrested person. He refuses. Then
Then, my lord, in that event, the police officer shall also inform the arrested person of his right under section 1. Soon he brought to the police officer the entry of the fact to who has been informed to the arrest of such person shall made in a book that I say, 37, in a book to be kept in the police station in such form as state government may by rule provide.
we want to pass so many orders. Unless there is a petition before us, we cannot pass an
That's
order.
true, very true.
So unless there is a nomination, to whom inform? That nomination has to be from the arrested person. Then every other action will follow immediately.
Suppose, my lord, the accused has not given any nomination.
What to do?
But that.
Newspaper
that
publication.
will be recorded in the.
That has to be recorded.
Recorded.
That
He
is one.
declined to give them.
That has
But
to-
that is being missing.
That is the answer we were looking for.
That is
It was not forthcoming from any of the sides.
Right.
Thank you. Yes, next.
Yes. As per office note 8/12/25 services awaited.
Petitioner is behind the bar from 28/5/2025, 198 Charges was laid on 27/6.
We issued notice on 28/11. 28/11, it is now 10 days.
Yes, I know from that, nothing has been served. Since, that is the office of the PP,
I think there is some pressure on the authorities for some reason where they are not being able to coordinate the entire matter in the last 2-3 days. Given some time, perhaps on the next week, you can have.
We have to take instruction regarding.
It has been submitted by the learned APP that the status of service on the respondent number 2 is awaited, whereas Mr. So-and-so learned counsel appearing for the petitioner has submitted that as per his instruction, the service has been completed. List this matter again. 19 দিব পাৰি 19th of December 2025 to enable Mr. Goswami to have instructions on the status of the service.
Lovely.
Yes, sir.
We have taken a step on 2/12/2025. We have taken a step, but service was not complete.
32.
I am in behind the bar since 69 days.
Huh?
I am in behind the bar since 69 days.
Since 90 days?
69
6 is
days.
there. 90 days.
Without
CD is not
Yes, I don't
received
see
yet.
there.
case diary has not been taken down. But Mr.
And-
So-and-so learned counsel appearing for the petitioner,
And
the
we-
learned APP has submitted that the case diary is awaited, as is the service report on the respondent number 2. Full stop. Accordingly, place this case again on
69 days, 7.
And on next week.
Next week.
next week. It's a motion matter before the holidays, choked. It is totally choked.
Immediately after reopening, yeah, 5.
5th, on the 5th of January 2026, along with the status report and the case diary called for. Yes.
I have like.
Yes, sir. Hmm.
The petitioner was arrested on 15/9/2025. Today is 88 days.
Hmm.
And the case registered
Very common,
section concerned. Well, the against the narcotic, the section is just intermediate quantity.
Intermediate quantity.
Yes, ma'am. So, 60 days is statutory pure. And one section is here, 27A,
Ah,
and it is 90 days. But I think 27A is not present here because some money recovered, but the person who is the arrested, he is 58 years old and his 3 sons, out of 3, 2 sons, they are earning, and the money was joint family.
We have not
how
looked at
much was
case diary.
recovered?
It is a ganja, total is, here, 1 kg, 750 gram.
Okay, and what was the amount of money recovered?
Money recovered, that is 4,62,500. But my lord,
Keeping at home cash, 4,52,000.
my lord,
2 brothers serving.
2 sons, my lord, they are
Who has been arrested?
arrested, my lord, that
The father?
58 years old father and son are earning person. And as per our instruction, my lord, money earned the son, my lord, and kept to the father. And police came and charged whole the house, my lord. And otherwise, my lord, section is intermediate, my lord, 88 days, my lord. And it is not the commercial, my lord. Though section, my lord, believe the.
Any
27A,
explanation how the ganja came to your house?
my lord, actually, I have stated, my lord, he consumed, my lord. He admitted fact, he consumed, my lord.
Yes, they not received yet.
I have admitted. my lord, that fact.
80 days, 58-year-old man.
88 days, man.
88 days, 90 days.
Yes, ma'am.
What to do?
27 he was there.
That is not commercial. 27A is not commercial.
Financial help.
That is another offense, that is.
Which one?
90 days. 27A.
27 is proceeds.
Yes.
Proceeds. He has an explanation for the proceeds. Sons are earning, both the sons keep.
Only
The
thing
money
is that
at
we have to take instruction whether charge is submitted or not. That is the plan. But other than 88 days today. 37.
Huh?
37 embargoes they are only 27A.
27A embargo is there, but 27A that 4 lakhs, he has some explanation, not small shops on rent. He has an explanation to earning sons. His expression speaks it all. Let him have his instructions whether the charge sheet is there. On the next day, we'll consider it. What do your sons do?
But one is 30 years.
What does he
and
do?
Other is 32 years.
Hmm.
And there will not,
If they say they are having small shops, then 4 lakhs is not
they are called.
conceivable.
Wrong mistri, madam. Honestly, I am submitting, madam. Sometimes cap, madam, the illiterate person, they don't use the bank system, madam. So sometimes whole the years earning money also kept.
He's asking for some time to find out if the if the charge sheet has been submitted. If not, in any case, it is how many days more? 2 days more.
2 days more.
2 days more. We'll have it on Wednesday.
Lordship.
Hmm?
2 days, 2 days Thursday.
Thursday?
Well, that Monday-
Friday we cannot have it.
Monday, man. Just telephonic inspection.
Monday.
Statement. Monday.
Okay. The learned counsel for the petitioner submitted that the petitioner has already spent 88 days in custody. Full stop. Learned APP has sought for a very short accommodation to find out if the charge sheet has been submitted in the meantime. Full stop. List this matter again on Monday. Monday detail. 15.
50.
Eta instruction. Nice.
I'm obliged.
44.
May I please, your lordship?
Hmm.
I was granted interim protection, lordship, and I have appeared before the IU and recorded my statement, lord. And in the meantime, my lord, my mother was also expired. I have annexed the medical documents during the filing of this bail application, lordship, and when the interim order was passed, she passed away.
As per allegations, Lordship, statement of the 183 statement of the victim girls, he has implicated the petitioner, Lordship. And he has appeared after getting interim, Lordship, and the statement recorded also.
Hmm.
But victim girls implicated him, Lordship.
But then one thing is there, if you see the kind of allegation,
Yes.
I don't know, 24 years, maybe too old for that, but there are times in Holi when
Yes, lordship, at the time.
there is no,
And
no.
there is no specific
It's no,
allegations
no.
in the FIR, lordship.
Huh?
There is no specific allegations against the petitioner in the FIR, lordship. Kindly produce the page number 18, lordship.
Just a minute. Yes, but if you come to page 12.
So stock and send messages to the.
Boolean if it is how they start, is it not?
Yes, Lordship.
And then the second one is tried to,
Yes,
tried to,
yes.
is it?
Yes.
How many days till now? Or
No, it is an
Anticipatory bill.
anticipatory bill, lordship.
Interim was granted earlier, he has appeared in
make it. The petitioner, heard Mr. So-and-so, so-and-so. The petitioner had been granted interim bail on 24/7/2025 with a direction to appear before the IO of the investigating officer of the Dispur PS case number so-and-so within a period of 7 days from the date of the order and to cooperate within with the investigation, full stop. In the event of arrest in connection with the aforesaid case, he was required to be allowed to go on interim bail of rupees 30,000 with one surety of the like amount subject to the satisfaction of the arresting authority, full stop. You are appearing as the,
For the information.
so what do you say?
But I'm,
The allegations level in the FIR is that the petitioner had misbehaved and attempted to misappropriately touch the victim girl. Full stop. The APP has submitted that the petitioner has in the meantime appeared before the investigating authority and has recorded his statement, full stop. The learned counsel for the petitioner submitted that the petitioner is ready to participate in any manner in the investigation as and when so required. In the above facts and circumstances of the case, the interim order dated so and so is made absolute. Anticipated bill application accordingly disposed of. মই এনেকে দলিয়াই দিলে তাত যদি সাউন্ড হয় কিবা বেলেগ এটা ৰাখি দিব কাপোৰ চাপোৰ এখন শব্দটো নহয়
45.
মোৰ কাৰণে ইজি হয় এখন থাকিলে দিগদাৰি হয় বুলি
35, Lordship.
Please, your lordship, in this matter, CD was called for.
We have not received the case diary. Petitioner is in interim actually.
You are in interim.
So list after vacation, Lordship.
The learned APP has
Yeah.
Ms. So-and-so appears for the accused applicant. Mr. Goswami learned APP has submitted that the case diary is yet to be received and that this matter may be listed after the vacations, full stop. Accordingly, list the matter after the ensuing, after the Bihu vacations.
19.
Awaiting on the 19th of January.
Lordship, I am on.
19th of January 2026, awaiting the updated case diary, full stop. Interim orders passed earlier shall continue.
Obliged, your lord.
46.
Please, your lordship. On the
Yes.
existing, the petitioner already is an interim, my lord,
Hmm.
and pursuant to the order of the court, my lord, I have recorded my statement. But the FIR, my lord, is page, my lord, page 12, my lord. Basically, my lord, it is a case, my lord, where the petitioner is doing the business of, my lord, Erica nuts, my lord. And my lord, from my godown, my lord, 114 bags of Erica nuts has been seized, my lord. And registration has been, FIR has been registered, my lord, under for theft stolen of my own property, my lord.
Yes, appeared, Lordship.
Yeah.
Mr. G. Alam, learned counsel for the petitioner has submitted that pursuant to the order dated 2011-2025, he has appeared before the investigating authority as required by the aforesaid order. Full stop, the APP has endorsed the above said statements on instructions, full stop. The matter relates to the allegations that. What was the allegation?
My lord, suspected, my lord.
That some
supposed
suspected Erica nuts were found within the campus of the petitioner.
Yes.
Of the petitioner, full stop. Having regard to the fact that the petitioner has appeared in connection with the investigation and has undertaken to further cooperate with the investigation as and when necessary. Full stop. The interim order, the interim protection of pre-arrest bail granted the petitioner is hereby made absolute. Yes.
For time being, lordship.
Huh?
There is 11 in court number 23.
ED has not been received, lordship.
Lordship, can they allow for time being? My senior will approve because, lordship, they have some point, lordship. Can you
Folks
allow
to
for?
what about the, this thing? You are appearing for the respondent number, very well. Yes, on Pishot.
For orders, item 38.
Yes, your lordship. This is a matter pertaining to a love relationship
Huh.
that I used to had back in 2012. But at that time, he has already served 70 years of his service in the Indian Air Force.
Hmm.
And by this time now he might have got retired and he has moved on. And at the same time, I have also moved on. So now here we are not aware that what his present address is. So from that day till now, we have attempted many times, but the services has come either not served or now recently the step which we took on this respondent number 2 has came to us back by terming unclaimed.
Hmm.
So therefore, in that regard, we are relying upon one of the judgment of the Supreme Court so that the service may be termed to be complete.
You are asking for quashing of an FIR.
Yes, I'm just looking after all these services and everything, but on the merit, one senior from the Supreme Court, she will be appearing for this. The para 10. If your lordship may just see the judgment.
Para 10.
Para 10 of the judgment, if I may read.
Yes. Section
It is thus clear that Section 114 of the Evidence Act enables the court to presume that in the common course of natural events, the communication would have been delivered at the address of the addressee
Section 27 of the General Clause Act give rise to the presumption that service of notice have been effected when it is sent to the correct address by the registered post. It is not necessary to ever in the complaint that in spite of the return of the notice unserved, it is deemed to have been served or that the addressee is deemed to have knowledge of the notice. Unless and until the contrary is proved by the addressee, service of notice is deemed to have been effected at the time at which the letter would have been delivered in the ordinary course of the business.
Where is the FIR? The FIR?
The FIR, your lordship may just find the type copy of the FIR is at page 24. This is the translated type copy of the FIR.
24.
Yes. The translated type copy.
Huh.
So the matter originally originates in the state of Gujarat. Later on, the Supreme Court intervened and Supreme Court transferred the matter from Gujarat to Guwahati by stating in the order that there has to be some.
No, we are just trying to find out if we have to apply this judgment.
Yes.
If you have taken steps, yes.
Yes, on the correct
APP,
address.
Page 25, the person has given his 2 addresses.
Yes.
Steps have been taken on those 2 addresses.
Yes.
Those are the only addresses known to the petitioner or to any other person as of today. So we'll have to presume that the
Service
notice
is
has been
complete.
served.
Yes.
Then we can go ahead with the plea. And since it's a matter of FIR and the prayer is for washing of the same, all we are required to see is that whether the allegations level therein demand an enquiry or not.
Yes.
Yes.
If it demands an enquiry,
Whether
matter
the-
ends. If it
matter-
does not demand an enquiry, matter goes.
Whether an offense is made out or not.
Yes.
That is all we need to see, whether it requires an investigation or not. Yes. Heard Swenson and counsel appearing for the petition also heard Swenson and APP.
Also, may I suggest one thing?
Ah.
For safeguarding the interest of the respondent,
Hmm.
amicus may be appointed. It's up to your lordship.
We can do that. There's no difficulty.
Just to safeguard the.
Okay, we can do that.
Because a legal aid for respondent number 2.
Legal aid would be a
Amicus may be appointed.
legal, if we go for legal aid, the question would be whether he's entitled to legal aid
That's a different issue.
or not, being a service holder at one point of time,
Yes.
perhaps a pensioner.
Yes,
He may
even
not be entitled.
Amicus also will be a question.
Amicus will be only on the question of law. It
Yes,
will
on
not be,
the
it
law.
will not be connected to the person
Yes.
concerned. So we can appoint a amicus, I think. This criminal petition had been filed seeking quashing of a certain FIR. Full stop. The petitioner in person has appeared today and has submitted that despite several attempts to have notices served on the respondent number 2 at the last known addresses and as reflected in the FIR itself, comma,
If your lordship may also just see page 48, the order of the Supreme Court. The para number 4. That on receipt of the case record, the transferee court is directed to make all endeavor for amicable.
if he does not appear, how do I go for an amicus? Amicable settlement?
That
Not-
is
not
again a
possible.
questionable.
Not possible. The order dated 25/11/2025 has recorded that the unserved notice have been received back with postal remarks such as in vernacular language illegible. The second one being unclaimed and the third one being unclaimed, full stop. The petitioner has relied upon the judgment passed by the apex court in criminal appeal number 1523 of 2014 to submit that which held as follows. Take paratin from here. Yes, learned APP has also made his submissions, and this court is of the opinion that since all efforts to have notices served on the last known addresses of the respondent number 2 have been made, comma, and the matter pertains to the year 2021, comma, the notices on the respondent number 2 may be deemed to have been served as required in law, full stop. However, to protect the interests of the respondent number 2, comma, this court deems it fit that amicus curiae may be appointed to assist this court, full stop. Accordingly, Miss Manisha Karen Brown. Does she? Yes. Manisha Karen Brown be appointed as the amicus curiae to assist this court in the matter, full stop. List this matter again. We'll
The
have
Lordship
it
may fix this matter on the second week of February, because the senior who will be appearing from the
on the
Supreme Court
second,
is available only on the
the-
second week.
to list the matter again on the 11th of February 2026. Huh? Full stop.
In the meanwhile, interim may be continued.
The learned counsel, the petitioner shall ensure service of copies of the petition upon the learned amicus curiae appointed by the court, full stop. The interim orders passed earlier in this case shall continue.
Let it be on a
Deep-
hearing day also.
Huh?
On a hearing day.
On a hearing day, you want it on 12th?
Yes, 12th.
12th or 10th, choose.
12th.
12th?
Yes, fine.
12th of February.
Deeply obliged.
Yes. 39.
Wait, please, your lordship.
Hmm.
Your lordship, I'm stressing on the interlocutory application, your lordship, which has been filed along with this criminal appeals.
Good.
Your lordship,
For stay.
yes, your lordship, for stay and for bail, your lordship.
Huh?
And for bail, he has been convicted under section 51 of the Wildlife
Why
Protection
not,
Act.
why not argue for acquittal or reversal?
Your lordship,
Huh?
well, if your lordship, ask me, because in the last three occasions, your lordship, the interlocutory application was supposed to be heard, but due to some paucity of time and all, your lordship.
We understand all that. What we are asking you is, why not take up the appeal at a go?
Your lordship,
Hmm?
can be taken, your lordship.
We have the records with us. We can make a request or we can have a scroll for the forest department to appear before us. Special BP Forest. And in the meantime, we can perhaps consider your submissions.
Lordship.
Itu তোমার item 39 কেটা আছে hearing এটো hearing নেই হ্যাঁ এটো order sir অলপ পিছত মাতি দিও স্ক্রোলটা দি দিও গুগল হ্যাঁ স্পেশাল পিপি ওয়াইল্ড লাইফ বিল দি দিও স্ক্রোলটা না
Your lordship, in the last date, what happened, your lordship, the Standing Council of Wildlife appeared and he said he submitted before the court, then since they were not a part in the trial, so their appearance might not be necessary. So they were not a part in the entire trial. That is one of my main ground, your lordship. Your lordship, entire exercise was done by the police, your lordship. Though the police is authorized, your lordship, there are certain instances, your lordship, the communication has to be made to the forest authorities or the wildlife authorities, your lordship. That has not been done, your lordship.
How does it prejudice you?
Your lordship, the thing is that is another thing, your lordship. That
How does the outcome of the trial
lordship,
be affected because some authority who also could have prosecuted you was not informed?
lordship, the thing is that your
Let
lordship,
us have some grounds.
the entire,
where we
if the
can
matter is
think of
taken in the
interfering.
entirety, your lordship.
Huh?
If the matter is considered in the entirety,
Huh.
your lordship will find that there are some instances where the doubt on the recovery of the substances arises. Your
Please show us.
Your lordship, if your lordship move on to
People-
the evidence
This is
part,
people.
your lordship. Your lordship, the learned trial court, your lordship relied.
We'll wait for some time, see if the SPP comes.
Lordship,
You also prepare,
lordship.
because you must be prepared in the IA. Go through the appeal once, we'll take it up, yes. বাকি কিটা মাতি লওক। এটা হলো পিছতে ফরেস্ট আহিলে দি দিব। And Mr. Parasar, it has been submitted that the police was entirely involved in the investigation and the trial. Wildlife was not even a party to it. In that case,
Wildlife protection case, yes.
but what you must have heard he said that it is
Wi-
wildlife was not even involved.
Wildlife protection case.
Yes.
PS case is not there.
Hey, but go through the records, find out
No,
if you
man.
need, if you are needed to do something.
Sorry, Lordship. Well, in this case, my lord, my lord, malicious FIR, Lordship. Headmaster of his school, my lord, has been, my lord,
Implicated.
in question, my lord, for my lord, 47 days in my lord judicial custody, Lordship.
Ah,
My lord, before going to Lordship, FIR, Lordship, for a time being, my lord, kindly see page 20, Lordship. That the informant has, my lord,
I may be. CD, we have not received.
my lord, today's 47 days, kindly see page 20, Lordship. For a moment, Lordship. Matter was, my lord, incurred by the, my lord, block elementary education officer, Lordship.
ah.
This is the fact, Lordship.
Let us have someone from the education department. Can ask someone to come from the education department. Yes, you are appealing for whom?
Respondent number 2, Lordship,
what do you
Vice
say?
President of School Management Committee.
Huh?
Vice President of School Management Committee.
What do you say?
I have filed the FIR, Lordship, instant FIR.
What do you say? Is,
This stage, Lordship,
huh?
I have no objection because upon perusal of the page 20, it is found that on misinformation by the some people or some resident on the
so
instruction.
now you are saying that your FIR was wrong.
FIR was wrong because I have.
Are
I have
you,
submitted
are you the
already-
person who signed it?
Yes, Lord.
File an affidavit to that effect. That I had filed a false information involving the headmaster of the school.
No, Lordship.
Listen to us, don't say no. File a affidavit by this person that I had believed some miscreants. I have lodged a false FIR against the headmaster of the school. And that, for that purpose, a person holding the rank of headmaster had to undergo incarceration. And the entire school activities were stopped. Minor children were made to give false statements. File an affidavit to that effect. Then we shall see what is to be done to your vice presidentship.
Vice President of the School Management Committee.
You are taking all this in fun.
No, Lord, I have some apology letter given by the.
Why?
Given by the.
Why was the FIR lodged at the first instance then?
On the
On the
instruction.
basis of some miscreants?
No, on the version of the guardian of the Sri Ellis victim of the Lordship.
Yes.
Later on, they.
Why did the
apologized-
guardians not lodge their FIR? Why were you supposed to be involved in it?
At that point, they are.
And now there is a handshake.
No,
At
later
that
on,
time, the
they.
handshake was on that side, now the handshake is on this side.
Later on, they make some apology letter to me.
This vice president is going to
My
have some
lord,
fun.
Guardians submitted apology letters that the on misinformation
guardian?
was done, Lordship.
Which guardian?
My lord,
The same
guardians of the
guardians,
girl.
the very same guardians who had made that
My lord,
allegations. Yes, we are not taking this lightly. You lodge an FIR against those guardians and the vice president. Have an investigation taken up as to why they could have moved the entire, there is some provision in law.
Yes, yes, madam. Otherwise,
We will direct them to file the affidavit. The moment the original complaint is found to be vexatious and false, we will direct you to take appropriate proceedings against the vice president and the parents.
No one can
This
be
will not
allowed
be
to
taken.
play with this, malad. If at all false, why this harassment? Why wasting the time of the court?
Things which are to be taken so seriously. It's fun. We'll trap him in this and we'll.
Later on, they
when he
submitted
feels
some
done, it will
apology
come for a
letter to me.
handshake. We will see the
I have
handshake.
the original copy
My
of
lord,
this apology
30
letter.
years in my service.
Have you, huh?
30 years in my service, Lordship. No problem was there, but this time, my lord, because of my lord, government fund was come, Lordship, some persons, my lord, from the area, my lord, demanded lordship money.
And now
I,
why,
my lord,
why
I,
are
my
they
lord,
repentant now?
What, Lord?
Why are they repentant now?
sorry.
Why the parents are repentant now that we have made a false allegation?
My lord,
Why are they
parents-
sorry
At the, yes, some information, misinformation.
from their children?
No, not from the outsider also. That something has happened with their.
Ask someone from the education department to be here. This block elementary education officer is giving clean sheet in criminal investigation parts.
my lord, departmental application was submitted before the BU lordship. And that was done, my lord,
Student
a
is-
letter was, this is the letter to.
We will
the
have
career
it once
officer.
someone from the education department is here. We are lucky Mr. Gogoi is here. We'll have someone from the education department,
My lord,
elementary education department, scroll the education.
annual lordship 47 days in judicial.
We'll have it,
custody, lordship.
we'll decide you in another 10 minutes.
That is.
Let the
Otherwise, I
council,
have the original apology letter. of
let the
guidance.
councils be here. We are taking this up a little bit seriously.
I'm giving the original copy of the apology letter submitted by the guardian.
When the matter is called up again.
Then lordship to heavy cost imposed as per the honorable Supreme Court as well as criminal proceeding to the complainant.
That is what we propose to do.
Heavy cost as well as criminal proceeding against the complainant.
We'll have
For
that-
harassing the petitioner.
That is what we have,
She have to or he have to compensate the petitioner.
that is what we
And
propose to
criminal
do.
proceeding also.
Have that Supreme Court order ready. We'll do it in a few minutes. Just take some time.
It is
It is
also-
to your benefit.
Seriously, 3 girls lordship. My lord, some, one girl, my lord, did not come, my lord, come to school, my lord, for last 5 days lordship. On the date of his alleged occurrence, she was not there. My lord, she was dragged into the case lordship.
Please take your seat for some time. Let
Yes.
the counsel for the education department be here
Lordship.
and we shall see what is to be done. After
Lordship.
some time, 10, 15
Yes.
minutes.
Obliged.
Item 39, where is? গগৈ সবটো গগৈ আহিছিল তো আহিব সি আছে ফোনটো লৈ বাহিৰ লাগিছে আৰু কি মেটাৰ আছে মিষ্টাৰ গগৈ
There's a point to clarify. Though the provision of the Wildlife Act is invoked, we are nowhere connected with it. It is the police who has launched the prosecution and this has to be defended by the prosecutor. And because the section 55 has been amended and police officer also are competent, not the below rank of SI to launch prosecution matters. So we have no role out there. So the learned
now
prosecutor has to
the difficulty is this from August onwards.
PS case.
When was that impugned order passed?
Your lordship, it was passed on
June.
June, your lordship. And
Is
since
there
then
a
we-
stay? No, there is no
Man,
stay. He's
PS
inside,
Inside.
he's inside bars.
Yes, man, that I understand.
Almost 6 months.
We are not considering the criminal, the IA criminal for stay because this
I
party to that party, we cannot let
Yes.
any more suffering.
Otherwise, man, it's a PS case.
They have not mentioned in the cost because of Goreshwar PS case number, no? এটা কোনো
Criminal appeal has been admitted for hearing
এটা কোথাও লেখা নাই।
and this sentence is what?
7 years, sir.
7 years rigorous.
I will assist it.
Should we consider the IA today?
Lordship can take up the main matter.
No, judgment.
What was found with you?
Judgment of,
Your
Just a
lordship,
minute, what was found with
now,
you?
as per the
Judgment of-
judgment, your lordship, the animal's bone and teeth. That
They
is-
were, they were replicas or they were found to be actual animal bones and skins? This is only for the purpose whether we are taking up the IA criminal or not. I'm just
lordship,
asking you for an
according to the
overview.
judgment, it Says that animal bones and teeth were found.
They were
that
ori-
panther. Now, there are also contradiction, your lordship.
Hmm.
Some of the evidence says this, your lordship, as a layman, your lordship, if someone brings a black skin, furry skin before me, I will definitely not say that it is a tiger skin. But your lordship, all the independent evidence goes on to say, we have seen tiger skins. And there is not a single independent witness who has witnessed the recovery, your lordship. Even PW3, who has been heavily relied upon by the prosecution as well as while delivering the judgment by the trial court, he has also not said that he has witnessed the recovery of those items from the appellant, your lordship. And there are serious contradictions. PW2 completely denies. And he said that he has been called to the police station and asked to sign. Same goes to PW4. PW5, who is another witness, he also is not supporting the prosecution case.
Huh?
Your lordship, there were 4 independent witnesses.
What do the independence witness say?
Your lordship, first I will take your lordship to the evidence of PW2, your lordship.
He was on bail throughout the trial.
Earlier I was in judicial custody.
Then he was on bail.
Then I went on bail.
He
Then
was
thereafter I
granted bail, he
just-
participated
I participated
and
in the
he's
trial.
behind bars. Now he's on appeal.
If your lordship may grant me bail,
No, we will ask for, we may go for suspension of the sentence further. Really, keep you on bail. Huh?
Below 5 years, directly, we are so lenient view, below 5. Now,
No, someone decides to give him 7.
Yeah.
And one thing we can just point out to you, hoping everybody will forget it on the next date like we do. The reason why it is 7.
My lord, I'll try to explain, my lord. Wildlife Act has been amended in Assam. Earlier it was 3 to 7. Now it has become 51B has been introduced. Now it's 7 to 10.
When
And-
did this come in?
Well, I'm just just a
This is a case of 2018.
18, my lord. Amendment is of 2010.
Amendment is of 2010, making it 7 to 10.
Non-bailable. And also, my lord, it
No,
has the
that
rigors of
7 to 10.
7 to 10. It has the rigors of NDPS, similar, somewhat
So he has been given the minimum punishment.
minimum.
He has been
Goes to
given the
7.
minimum.
And also in the Wildlife Act, section 57, there's a presumption. Subsection.
The presumption.
Presumption is there, 57. He has to rebut that.
Hmm.
This was to amendment to 22. 22 is over.
For my amendment.
You are accused number
This number, your lordship,
A123.
This number.
You are appealing for accused number what?
I'm for Ali Ahmed, your lordship.
Uh-huh.
Ali Ahmed, your lordship. I'm for accused number 3, your lordship.
3. What
Accused
was
number
3's
2 has expired, your lordship, in the meantime.
and what was
so the
3's
trial
role?
has been, it has been abated, your lordship. And I'm for,
Is A1 and A3 related?
no, they're different, your lordship.
Any appeal filed by A1?
I have heard someone has filed an appeal. I have heard, your lordship. I'm not sure about.
How do we trace that if any other appeal has been filed, sir? How can we find out if any other appeal has been filed regarding the same judgment? Can it be traced out, huh? Trace out. So we'll have to hear the PP then.
Yes, my lord. I'll assist him.
You will assist, you don't have copies.
No, I have published.
His copy, he has given his copy to me, so I'll assist.
Okay, then how soon? Either we either we let him have bail.
Next
You
week.
prepare and we come back and argue.
Next week.
Next week is
Next week,
motion.
no, plate is full, my lord.
Immediately in the reopening.
Need reopens, my lord.
8th? 8th? 8th will take up the entire matter. And now we'll record Mr. Parashar and Mr. Gogoi.
My lord.
And they will not they will not allow the file to go anywhere. They will protect it like they protect our wildlife. Yes.
Might.
Huh?
Yes, my lord. Definitely.
In the meantime, your lordship, if I may be, go off, your lordship.
They'll see from what we have seen.
Lordship.
The bones are of a cat, the skin is of a cat, the hair is of a cat, recovered from you.
There's a question of
So
recovery.
if there is a technical fault, if you can find out technical faults, it will allow the acquittal. It may entitle you to an acquittal, but at this stage. Yes, Mr. Gogoi, one thing, we are allowing that bail because he was there, he was on bail during the trial
Yes,
and he participated.
yes, madam. That can-
Yes, give the. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. D. Gogoi learned counsel appearing for the special PP. Forest Department also heard Mr. K. Parashar for the
Statement.
state, full stop. This appeal is against the order dated
625.
order at 13/6/2025 passed by the Court of the Learned Session Judge Baksa Mushalpur in special WL within bracket P case number 12 of 2018. By the judgment dated 13/6/2025, the appellant has been convicted for an offence under section 51 of the Wildlife Protection Act as amended. The appellant has been sentenced to undergo rigorous imprisonment of 7 years with a fine of ₹50,000 in default of payment of fine to undergo simple imprisonment for 2 months, full stop. Notice in this case was issued on 4/8/2025, full stop. The records of the trial court had been received, full stop. The learned counsel for the petitioner has submitted that during the period of the trial, the petitioner was allowed to remain on bail. And he had participated in the bail, in the trial proceedings. Full stop. He further submits that the petitioner undertakes to participate, to extend all cooperation during this appeal and appeal also, full stop. However, full stop. The learned special PP and the APP have objected to the bail petition. However, given the facts and circumstances of the case, since the criminal appeal is already admitted for hearing and the trial court's record have been received, this court is of the opinion that the petitioner may be allowed to go on bail. What was the earlier bill? What was the earlier amount? 25. Go on bail of ₹30,000.
TCR to retain. TCR retain or review. And TCR is there, and TCR will retain.
We will retain it. Anyway, it's a disposed case. Where will the TCR go? It is a disposed case. 30,000 with 2 sureties of the like amount, subject to the satisfaction of the special judge. Yes, to whom? The special judge.
Special judge.
To the special judge.
No, it's session judge.
To the session judge.
Baksa Mushalpur.
Session judge Baksa Mushalpur. However, condition with the DDO, we shall not leave the territorial jurisdiction of so-and-so. He shall not indulge in any forest-related activities during the time of this bail. Yes.
Bail granted then may not be in 80.
List this matter accordingly in the month of February for final decision, for final consideration. Yes, A to Dioxon education or to the data cell. I to disposed of. I disposed of a criminal appeal to list this matter again on in the month of February on a date to be fixed by the registry. I is disposed of. Yes, education. You have any inspector, sub-inspector of police in the department, engaged in the department?
No, Lordship.
Kindly have page 20.
Lordship.
Last line.
Sorry. Lordship, it is.
POCSO
Lordship.
certified, nothing happened that day.
Lordship.
Now, we are not on that. Now come to para number 1.
Numbers of victims and submitted their apology letter.
Letter for their
Mistake.
Victim.
Lordship.
POCSO says no identification of the victim.
Lordship.
Your BA is going around identifying the victims. obtaining apology letters from them. Was this done on the direction of the higher ups, as you call them, or is it done only on the direction of the DEEO? If it is the DEEO, then the DEO and the BO, were they not under an obligation to have informed that there is already an FIR registered, investigation is going on, hands off, we don't touch it?
Yes.
That should have been the attitude. They conduct their own inquiry. So that is a big problem. So we will bring this bail petition to your notice. The learned counsel for the petitioner will give you one extra copy for you to take, to inform the department regarding the issue.
Lordship, let her personally come before.
So no, not necessary. There are people who act in good faith also.
Julia.
There are persons who act in good faith, try to run the school. They may know that the headmaster is this kind of a man, that kind of a man, good man, bad man, and they are doing their best to help the society run the school. We do not know. But they are not required to do this kind of thing is what we want them to know. Penalty on them at this stage, their inquiry report means nothing to us. In a criminal proceeding, the BO saying, no, he is innocent, it means zero to us. Is it not?
Yes.
But this has to be told to the department. So we will record your name, ask him to give you a copy. You will send it to the department along with the copy of the order so that the department comes to know where they should step in and where they should not. Number two.
I indicate just three things, Lordship.
Yes.
Regarding compromise part, Lordship, regarding misuse of the criminal proceedings, Lordship, the lodging of FIR and other things, recently Supreme Court has imposed 10 lakh cost to the complainant. That judgment I will forward it. Even also exactly similar to POXO cases, Delhi High Court imposed 10 lakh cost or 10,000 cost to the petitioner, Lordship.
Because?
The 10,000 cost to the complainant, Lordship.
A complainant, yes.
Compromise part.
Because they are coming for a compromise.
Compromise part, Lordship. Even recently Supreme Court another judgment, when they have come up with a compromise petition, Supreme Court negated it.
No, here the issue is not one of compromise, sir. What has happened is they alleged against him.
No, sir.
Then the informant says, I was misinformed.
That's part is Delhi High Court even, Lordship.
Now, if they say that I was misinformed, it was a complaint by the students.
No, sir.
This man had no business to go and lodge the FIR first place. Second one, he had no business to report it to the department and have an inquiry
Yes,
conducted into the thing. Thirdly, the parents do not go to the police station. They use the SMC of the,
Yes.
so this is being, the school is being put to a big heavy loss.
Yes.
So 10 lakhs is something, yes, you have
Yeah.
given us a boundary. We were on a, without boundary, we were trying to think what can we go up to.
And
Very
just-
heavily, we are
just the
coming down very
indicate-
heavily on this, Vice President.
Just I indicate the misuse of power, even Lordship, the Delhi High Court case, exactly same situation, misinformation, Lordship. I will provide the judgment, Lordship.
Kindly brief.
See,
I'll
at
provide
this
that.
instance, I want to state the true story, Lordship. At that day, there was a crowd and police was also arrived there. After that, the local peoples were informed me to come there as I was the nearby from the school. And that after I came and at the instruction of local people, I have instituted this.
You collect the money from the local people. We
Thereafter-
will give you that, we will
after
give that
possibly
required
FIR
to you. Yes, take down. Heard Mr. So-and-so learned
I'm
counsel.
supplying the original. copy.
Otherwise, Mr. Parashar, with the statements that have now come on, bail should not be a problem to the headmaster. What do you say?
But thing is that this is from the persons, but here statement of the girl is not before us. Because CB is not there. There must be one statement of the girl, one statement of the girls.
Sir, can I produce the original apology letter given, submitted by the,
Not by the girls,
here it is
by the
stated.
parents.
Now,
Girls are
what
of
I'm,
which-
what I'm submitting, Lordship, as on today, 47 days, Lordship, something is going, is required to be investigated by other part of, my lord.
Has he been placed under suspension? Can you find out? Kindly find out over phone if this man is under suspension or not. this,
Interim-
Abdul Kalam Azad, huh?
My lord, the interim bail may be granted, my lord. On demand, sir. Today, sir, my lord, 47, 60 days offense, lordship. Oh, 13 days is a head lordship. That is why he may be protected by interim order lordship.
We'll look into it. Can you just find out this, what was the school?
School is lordship. School name.
Hmm?
কি স্কুলের নাম কি?
Number 7.
Number 7.
Sitalmari
শীতলমারি পাথার MKB, মক্তব। মক্তব, MKB মানে মক্তব।
Give this to the, give it to head deduction, by the video. তেওঁ স্কুলৰ নামটো লৈ লওক। স্কুলৰ নামটো লৈ পেলাই তেওঁ খবৰ এটা লওক that DO you can press up. Juria, BO, Juria, whether petitioner is under suspension or not.
Deemed suspension lordship.
Hmm?
He will be deemed to be suspended lordship. Lordship.
Whether the department knows whether they are taking any action against him. It depends that yes, heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. KK Parashar, learned counsel. You can go and find out, we'll wait. Also heard Mr. KK Parashar, learned counsel appearing for the for as the APP. Mr.
R Hawk.
R Hawk appears for the respondent number 2. You have any information whether respondent number 2 was served? Do you have any information whether respondent number 2 was served? Huh? Because 8/12/2025 service was still awaited.
Now they have appeared.
Where have they received the information from?
My lord,
Huh?
I have received the information
From?
pending the cases from one of my friends.
Before the learned trial court, sessions as also, my lord, no objection was submitted, lordship. In the order, it is, my lord, it was not annexed lordship, but in the order, it is
Because
reflected.
he is supporting the case of the petitioner.
This case relates to,
My lord, not it is, my lord, for the past. My lord, this is the order, lordship.
this case relates to an FIR lodged by
My lord, on 29/11/2025, lordship, second para, my lord, first paragraph, second paragraph, seen the report, informant is present and has filed no objection against bail payer. This is not first time, lordship.
this is not the,
This is not first time before your lordship.
no, we never said that. We did not say it is the first
Lord,
time.
yes, my lord, not said.
We did
But
not say
then
it is
take
the
my
first
lord.
bill.
I am submitting for my own.
Hmm. This bill petition arises from an FIR dated 25/10/2025 lodged by Kulsuma Khatun within bracket, Vice President of 7 number Shitolmari Pothar MKB, comma, wherein an allegation had been leveled against the accused applicant that while serving as the headmaster of the aforesaid school, the accused applicant had 4/12/2025 and the matter was fixed today, calling for the case diary, full stop. The case diary is yet to be received. Stop. The office note dated 8/12/2025 shows that the service report on respondent number 2 is awaited. However, Mr. So-and-so learned counsel has put in appearance on behalf of the respondent number 2, have you filed a wakalatnama?
Yes, Lord. Yesterday I have filed a
Ah.
wakalatnama.
By filing wakalatnama, full stop. The learned counsel submits that his client has received information of this case through a friend, and therefore they have appeared, therefore he has been instructed to appear today, full stop. When the matter was taken up, the learned counsel for the petitioner has submitted that the allegations leveled in the FIR are wholly false and had been made only because new funds have come to the school and there was an enmity with some persons who had manipulated the circumstances to have the FIR lodged, full stop. The learned counsel for the respondent number 2 has submitted that respondent number 2 would have no objection if the privilege of bail is allowed to the applicant herein, since the parents of the alleged victims as referred to in the FIR have submitted apology letters to the respondent number 2 stating that the case was that they had instigated the respondent number 2 to file the case on wrong premises. See, the records produced by the learned counsel for the petitioner shows that the petitioner, that the minor children had already given statements under section 183 BNSS against the petitioner, full stop. The situation created in the present case is contemptuous, full stop. When allegations are leveled against the head of the institute where minor children are sent for education, and then during the proceedings, then in a bail proceedings, comma, the informant comes up to state that the FIR was lodged on misinformation, comma, this court cannot take the matter lightly, full stop. It is also noticed that it was none of the parents of the alleged students who were ill-treated at the hands of the accused applicant who had filed the FIR, full stop. The students before the learned magistrate, while recording their statements under section 183 BNSS, have implicated the applicant as per the orders of the learned special judge POCSO, full stop. The accused applicant has been behind the bars for the last, how many days?
47 days.
47 days, based on an FIR which now the respondent number 2 claims was filed on misinformation.
24 days.
Full stop. The records of the bail petition also contains an enquiry report by the Block Elementary Education Officer addressed to the District Elementary Education Officer, wherein the Block Elementary Education Officer has quoted thus, a page 20, last paragraph, after concluding a thorough inquiry and inspection, totally fictitious. It is also seen that the aforesaid block elementary education officer has come to a conclusion that the SMC president, was it the vice president or the
Vice
president?
President.
Huh?
Vice President.
That the SMC president, no, that the informant has been referred to as the SMC president, whereas it has been stated that the informant is the vice president. Full stop. Allegedly, the said informant had told the block elementary education officer that she is totally unknown about the matter. Full stop. She had also prayed for withdrawal of the case against the head teacher. Full stop. The case diary as called for in the matter is still awaited. Bele paragraph, huh? Is still awaited. Full stop. List the matter again on this case diary. We want on a very urgent basis.
16,
16th of January,
16 or 17.
December. Okay. 17th of December, 18th of December, 17th of Buddha Sabuli, 19th of December 2025. We'll have some time. 19th of December 2025, by which time the investigating authorities will ensure the submission of the up-to-date case diary to the learned APP. Full stop. Since the vice president of the school, oblique the informant in the FIR, has retracted on the allegations level in the FIR, comma, the respondent number 2 shall file an affidavit before the 19th of December stating her entire stand before this court, comma, failing which her personal appearance will be required on 19/12/2025. During the course, huh?
Regarding the BE or letter.
Yes. The court had requested the presence of Ms. B. Deka, learned Standing Council Education Department, who shall be supplied a copy of the bill petition with by tomorrow, and who shall thereafter have the same forwarded to the authorities in the education department to have instructions as to whether the block elementary education officer had the authority to investigate into the allegations or level on the applicant regarding the POCSO, regarding offences committed under the regarding offences committed which are covered by the POCSO Act. This court requests the presence of Mr. K. Gogoi, learned additional government advocate in the matter, learned additional government advocate, PP and Standing Council Higher Education in the matter, to assist the court on the next date of listing. On 19th, sir, we will decide. On 19th, let the affidavit come. Everything can be decided.
As an interim lordship.
It appears that you were wrongly framed. And for
you're
that
right.
reason, we just need an affidavit from his part, because neither the CD is here. We have thought about it. We have thought a lot about it. With nothing on record today,
On that, he
it will not be very,
appear, lordship.
huh?
My lord, if bail is cancelled, my lord, bail is rejected, he will.
No,
appear,
no, what we are saying is this, without anything on record, these are all submissions made. CD is even not here.
Then lordship, otherwise, all man, kindly see the photographs of that person, my lord, with the.
I've seen
My
that
lord,
old man, I've seen everything.
lordship,
And we have,
what is
and
that?
we have called for the assistance of from all the departments through one person.
Lordship, lordship.
Let
has
it be
power
on the
to grant interim bail, lordship.
Let it be on the 19th. Let something be here on record. we assure you no injustice
My lord,
from this court.
As part of,
Huh?
as part of.
The matter has been heard at length. সেইটো আগতে একদম ওপৰত লিখি দিব হ'ব the learned councils for all the parties have been heard at length কৰি দিয়ক we'll decide on the 19th we'll give
Then
a keeping
short
it with us
given lordship.
before 19th of December
Today is 11th lordship.
huh Saturday Sunday minus so we have 6 days how much shorter he will have to file an affidavit the department has to take the instruction and we may make observations which would be to your benefit, who knows, based on their affidavits. Yes.
Obliged.
41.
Obliged.
Yes, madam.
May I please your lordship?
Hmm.
Your lordship, this is a quashing proceeding against the quashing proceeding, which is normal for your lordship.
What do you want
For-
quashed?
Yes, DV case. And in this case, your notice was issued, your lordship. And as per office note dated 24/10/2025, your lordship, unsub notice, that is registered post has been unsub with a report that no person in such address is there. But the address has been furnished by the complainant herself only.
To whom?
Address was furnished in the DV case.
Take steps once more.
Your lordship, normal procedure also was taken,
Huh.
but the notice to district judge has not been,
So we will await that.
that
Take-
is service abated, and we have also pursued the matter.
Mm.
On 18/9, the notice was sent from this, from the section concerned
Mm.
to the district and session judge, but the matter is still pending in the Munsif. But there also we have searched for the notice, it's not been found.
How can there be a notice going from the High Court, it goes missing?
Yes, your lordship.
Yes, we'll do, we observe that. Yes, heard Ms. So-and-so learned counsel appearing for the petitioner. Full stop, the learned counsel for the petitioner has submitted that as though as per the office office note dated 9/12/2025, service report in respect of respondent number 1 has not been received back by the section till date, upon inquiries being made by the counsel for the petitioner, it appears that the notices were sent from the registry of this court to the district and registry of the district and session judge,
Kamrup Metro.
huh?
Kamrup Metro.
Kamrup Metro, which were then forwarded to the
Process server.
process server, full stop. However, no report could be traced out, even there, full stop. The registered AD has come back
Yes, your lordship.
stating what?
No such person is.
No such person
Is there in the address.
at the address, although the notices were issued at the address
Address.
given by the respondent number 2
Respondent number 1.
as by the respondent number 1 in the who is the respondent number 1 here?
Neha Sharma.
Where do we find it?
Is in page number 4, your lordship.
No, why is she a party?
Please file the DB case yourself.
Okay.
And against the mother-in-law, sister-in-law, and 2 other persons that were not, one is tenant and one is the neighbor. Not against the husband also, your lordship.
At the although the respondent number 1 hearing although the notices in respect of respondent number 1 hearing were given the same as given in her DV case filed by the respondent number 1, full stop. List again in the 3rd week of January. Awaiting the service report on the respondent number 1, full stop. Registry may also issue reminder to the registry of the district and session judge Kamrup Metro for the status of the service of notice sent. Yes. Let them give a office note.
Date may be fixed, your lord.
3rd week of January, madam.
Date is fixed, then
It
it's
will come up 3rd week of January, from Monday to Friday, 1 day it will be there.
highly obliged.
Wait, please, your lordship.
Yes.
Lordship, this is the case, lordship, perhaps remember, lordship, first time 376 allegation is come up against this petitioner. lordship.
Yes.
That case, lordship.
Mm.
And now, lordship, last day, lordship has asked me to confirm the next date, lordship. Next day is 12/3/2026, lordship. That in the record, lordship, it is reflected, lordship, on the framing, charge framing case.
Okay.
Because the FIR doesn't whisper about the 376 lordship, suddenly in 161 and lordship, once that was not there lordship, suddenly in evidence, she said that lordship.
And, can we have it on the, in January? Since it is March. If we have it in January and try to dispose it off, either which ways it will be more feasible.
There was no ingredients of rape, that is not.
We understand that.
medical, yes.
We do understand that, but, we were awaiting the.
For the informant.
Huh?
Regarding lordship informant, the appearance.
Yes, yes.
That is.
We have to await the informant for some more time. Since it is in March, we'll keep it in January. And then today we were given a judgment where if we have taken the proper steps, we can presume service of notice and proceed because it's a washing petition. We can have the assistance of the APT
Step has
also.
been taken lordship long ago, so for the lordship office.
We are not doing that today, sir. We are not doing that today. We'll keep it in January. Await it. Yes. Heard Mr. So-and-so learned counsel appearing for the
Petitioner.
petitioner, comma,
Instead of taking presumption, lordship can send the notice through OC concern so that some report will definitely come because this is in criminal proceeding. Presumption and
it is seen that the
Office notice.
service of notice on the respondent is not complete. Respondent number 2 is not complete, full stop.
Services.
The learned counsel for the petitioner has submitted that the matter in the before the learned trial court is now fixed on 12/3/2026, full stop. In that we have the matter. The petitioner to take fresh steps upon the respondent number 2 to be routed through the registry of this court and which shall be executed through the officer in charge, through the
officer in charge.
officer in charge of which police station? Tamulpur Police Station.
Tamulpur.
Her address is Tamulpur Police Station. Full stop. Steps to be taken within a period of 1 week from today. List this case again. 3rd week of January at a date video. Heri episode. Bihur episode. 21st of January 2026. Upon which date, by which date the service report routed through the registry and the officer in charge Tamulpur Police Station shall be placed before this court.
Can it be lordship 25th January?
25th of January. 4 days back, we are no problem.
Of life.
Bringing it ahead becomes a problem. 25th, you would like it to be a 25th?
Oh.
Did you tell who is it? ভাবি চিন্তা কইছে
23rd also probably on.
এখন 26 এর হলিডে লিস্ট এখন আছে না ক্যালেন্ডার এখন আছে না
29 loss.
29th of January.
Yes, sir. I do agree.
এতিয়া কোনটো
For hearing, item 54.
এটা আছে
কি ক্ষতি হলো এটা?
আৰু পাঁচটা আছে হিয়াৰিং Yes, let us hear.
Lordship, here in this matter, my senior is leading for Lordship. He already left. The board.
What was the challenge, sir?
Legal Lordship, I am challenging that.
GR case number so and so. This one you are challenging? No. Criminal appeal.
Revision, Your Lordship.
No, you are challenging something of a criminal appeal.
Yes.
Yes. What happened? What is the short story?
Yes. Short story is that my lord, appellant to attack the respondent, husband and son, my lord, in their premises in Tea Garden, my lord.
husband and son were attacked
Informed
by?
is the wife of the injured person, the victim, my lord.
Huh.
And there is two victim, husband and informant husband and son, my lord.
Hmm.
Hospital and trial court, there is a trial, my lord, they has been convicted under 223 and 147 and something, my lord.
Then they went
2
for
years
an appeal.
imprisonment and 6 months and 2 months respectively, my lord.
Huh.
Thereafter, they filed an appeal before the session judge, my lord.
Hmm.
Session judge dismissed the appeal and after the order passed by this trial court.
Hmm.
And against that, they came to the revision, my lord.
You are in revision against that. Those 2 years that you were required to carry out has been carried out.
Yes, yes, my lord.
So therefore, now you will not get any further instructions from the petitioners. You have to choose a date when you need to appear so that we can decide it because it is pending in this court.
Yeah, your lordship.
No, you have to choose a date. You want to do it today?
No, lordship.
No.
After vacation,
After the case.
This criminal revision petition has been filed. Selling the order dated. Selling the order dated 16/3/2012 passed in GR case number 1143 of 2008 and the impugned judgment and order dated 11/2/2014 passed in criminal appeal number 14 of 2012 full stop. The learned counsel for the petitioner has submitted that the sentence imposed upon the petitioners was imprisonment for a period of 2 years, full stop. And that the petitioners have already undergone the same full stop. List this matter again in the month of February. List this matter again in the month of February 2026 on a date to be fixed by the registry for final consideration. Since the learned counsel for the petitioner has sought for some time to prepare the case. Yes.
341, 324.
Does anything actually remain for us to decide now after
Lordship, trial court has been.
2012, the conviction came.
Yes, lordship.
14,
The
2 years
revision is-
gone,
yes.
2 years gone.
It's been.
Then appeal.
1.5 decades, your lordship.
Only
Most
thing
of
is
them
to
have
decide
gone
also whether the order passed by in passed
Does
appellate
have
court,
any-
whether there is any.
That
Whether
is
it
what
is in
was
that-
proceeding.
or not.
Conviction has been sustained by a lordship trial court is corroborating by that case diary. Case 161 statement. Your lordship, 161 statement cannot
Oh.
be used for the corroboration. It can be used only for contradiction.
Okay, we'll finish it in February.
Lordship.
Yes. 45, who appears? It is. Just a minute. Item 45. What was the punishment given? Dowry debt.
This criminal
Hmm?
appeal. Revision.
No, what is the, three years, 2014. Hmm?
Lordship.
3 years, 2014, 2017, he has already undergone.
He is not,
Huh?
probably he is out of, he is not behind the bar.
Sorry?
He is not behind the bar probably because this is 3 years.
So that is what, 17, he's out.
No, may not be.
Why?
Because if he is on, this is, today it is only. This is appeal only, probably he's not behind the bar. Because 3 years, lordship, he probably, normally he gets bail. While suspending the sentence also.
There may be a bail with suspension, na? So therefore, he is not interested. Huh?
Otherwise. he would
None
be-
appears for the appellant on call. This is a criminal appeal of the year 2014. List this matter again in the month of February 2026, giving one opportunity to the appellant to ensure appearance on his behalf.
6.
Yes, sir.
Maybe listen, Lordship. But I am appearing on behalf of M. Hussain, man, who is out of station, man, for his wife treatment.
My lord, will kindly just have a look at the last order, my lord. This is a case under the NI Act, where the petitioner was convicted by the trial court, sentenced to undergo 6 months of imprisonment and to pay a fine of rupees 8 lakhs. During the continuation of the trial, the petitioner came forward suggesting that they want to compromise the case. That went on, my lord, no compromise was entered into. Finally, he gets convicted. He prefers an appeal. Appeal also gets dismissed, my lord. In fact, during appeal also, this proposition of, my lord, compromise was placed but never carried out. Then they preferred this revision. And your lordship will note, from 2024 March, they have been dragging this case, saying that they will make the compromise. Eventually, my lord, there's an order dated 15/9/2025, whereby they came and said that they are agreeable to paying this amount, and they would be paying rupees 1 lakhs in the first installment. This was in September. Thereafter, once they paid 80,000 rupees, subsequently they did not pay anything. And on the last occasion, this honorable court was pleased to fix the case for hearing. Now, a couple of days back, my lord, another 60,000 rupees has been deposited.
And so total now 1,40,000 is
40,000
deposited. How
and
much,
out of 8 lakhs, and there was another 1,60,000 which was paid during appeal because of section 140.
320 paid.
My lord,
160 then 160 now.
160 and 140 now. So 3 lakhs has been paid, 5 lakhs is pending.
Remaining.
Remaining.
Yes. Mr. Ahmed is out of station.
Out of.
It has been submitted by the learned counsel appearing on behalf of Mr. M.
Khan.
Ahmed that he is out of
A-
station. Huh?
Ek halak.
You are A. Khan. It has been submitted by Mr. A. Khan, learned counsel
Ek
appearing.
halak.
A. Khan, learned counsel appearing for Mr. M. Ahmed that Mr. Ahmed is out of station and therefore the matter may be taken up on some other day. The learned counsel appearing for the respondent has submitted that out of a total settlement amount of rupees 8 lakhs, the petitioner has till date now only paid rupees 3 lakhs, full stop. List this matter again in the month of March 2026, by which date the petitioner shall ensure payment of
When the learned counsel, petitioner counsel had called me, my lord, and he had said that by January they are willing to pay the entirety of the amount. my lord.
ठीक है. List this matter again in the month of February 2026. Full stop. The learned counsel for the petitioner has submitted that the petitioner, learned counsel for the respondent has submitted that the petitioner had informed him that the entire amount would be paid within the month of January. Full stop. In case it is provided that in case the entire amount is not paid within the month of January,
Matter may be heard and decided on.
the matter would be taken up for hearing and decision on merits.
Deeply obliged.
Organized, man.
So this is a appeal against conviction.
Hmm.
Appellant is convicted under section 10 of the POCSO Act and my lord sentenced to RI for 5 years, my lord. And my lord, he is in jail, my lord, from the date of judgment. So about 1 year, 2 months, he is in jail now.
Yes, sir. He's praying for this IA criminal for bail.
Probably this is come for final disposal.
Yes,
So
sir.
it is in hearing list.
Paucity of time, what to do? I could take it up. What are your grounds otherwise in the
My
appeal?
lord, the main thing is that, my lord, here the incident occurred in a school. What the appellant before lordship is a headmaster of the school. Allegation is that he has molested, my lord, students. But the entire incident occurred in a school where there is only 2 rooms. 5 classes are there, my lord. The evidence, all the witnesses.
Improbability.
Improbability and my lord, also, my lord, there are some contradictions in the statements, my lord. And my lord, the third thing is that these are the victims. All are, my lord, child witnesses. So my submission is that, my lord, they may be tutored, my lord. So also considering the, my lord, entire circumstances, my lord.
That ground is not appealing to us. Minorities proved, you have to show that the statements are contradictory.
Contradictory.
That is your only
That are the
escape.
basically grounds. my lord.
Basically the victim statement.
Victim
They have to bring in contradictions.
then only they can.
But the main thing is that, my lord, there are two rooms and it is, the allegation is that, my lord, during the school hours, he has molested. But except the victims, nobody has seen, even the teachers are there. And some of the students are also examined, nobody has seen anything.
Probably will be same submissions will be there. And here in this case, probably today hearing may not be concluded, but
Little
only thing is
difficult.
that Lordship may consider my detention period, Lordship. I am having one judgment, Lordship, of Honorable Apex Court, which says, Lordship, if fixed term imprisonment is there and he has undergone a substantial period of sentence,
10
his,
years.
release may be considered, Lordship. And
10 years you have,
fixed term
10 years is what you are sentenced to.
Yes.
And what have you undergone till now?
3 years, 3 months, 15 days. And Lordship, that judgment which I am relying is also of NDPS case.
And that shows how many years, how many days, how many months?
Here, Lordship, he has undergone 4.5 years.
Huh?
4.5 years in that case. But the proposition that he has undergone and similar case, Lordship, our High Court also followed, where Lordship 2 years considering that period he was granted bail.
High Court has followed it.
Lordship.
Huh?
Lordship.
কি হল?
সম্বন্ধ দিশা। In that case, where Hawa High Court granted 2 years, 5 months, 23 days. And in fact, Lordship, here that quantity is also.
Their position was not with the applicants.
Position
in-
was there.
Mr. Swain says refer to the evidence of the prosecution witness number 2. According to Mr. Ahmed, narcotics were not found in the possession of the applicant. Now, in this
Their
case,
position was from their position. Yeah, in
But here in this case, Lordship, what I am, therefore I was referring to that quantity, that here quantity, if individual quantity is taken, then Lordship, it will be intermediate quantity, where maximum punishment is 10 years, minimum punishment is not there. And in that case, Lordship, because
but the trial court has taken both of them together.
all three quantities together, Lordship. So ultimately, if I pay for sentence also, then also it will be reduced, Lordship, ultimately. Because if they go beyond minimum sentence, that section 32B is there, they have to give specific reason for that purpose. That reason is also not there for some giving maximum sentence. So in that case, Lordship may consider our bail prayer and maybe fix for hearing and a fixed date. We will argue the case.
Today, this case has been listed for final disposal. As today, there is a possibility of time, Lordship, it cannot be. But if Lordship is deciding the issue of releasing him on bail, then Lordship, 2-3 things will come, Lordship. First, Lordship, section 37, whether because both
Consider.
the persons are from Bihar, Lordship, not from Assam.
Oh.
Both 3 persons are from Bihar, not from Assam. And apart from that, Lordship, when I have gone through the witnesses part, Lordship, evidences part. 3 seizure witnesses are there, independent, they have implicated them. So, Lordship, apart from that, Lordship, there are some judgments also in Om Prakash Sahani cases, Lordship, that when there is a scope of acquittal, when there is scope of acquittal, then the bail may be looked into.
Yes.
But when there is no scope of acquittal, then Lordship will not go to the entire fact, Lordship, what are the evidences, but in entire way, Lordship.
And therefore, Lordship, I have not argued
If the
for acquittal. I have only on sentence part. Because even if it is converted, then also, Lordship, maximum sentence cannot be given.
Then we reject your prayer for bail because we will decide whether the sentence will be this year's or these years. Ultimately, you have to undergo that little period.
For bail purpose, that I can also place, Lordship, that merit, what he has said, Lordship, that if there is no chance.
We are not on that. Once you argue that the entire conviction is wrong,
Lordship.
question of bail, because you may not be required to undergo incarceration. In the present case, your argument is that it should not be 10 years, it should be this years, it should have been taken separately, it's an intermediate quantity, punishment will be less. Punishment is there.
Lordship.
So if it was not 10 years, what would it be?
Because.
If it is not 10 years, what will it be?
It may be lordship 1 year, 2 year, 3 year. anything.
Subject to a maximum of the period undergone.
Undergone.
So some punishment has to be undergone.
Lordship.
We'll keep it in the month of January on 27th of January.
Even if your lordship.
Period
dispose of
undergone can-
Today by giving that period undergone, I will be satisfied. Because ultimately, lordship, because if the maximum sentence has to be imposed, other than the minimum sentence, there has to be reason. So in the present case, the quantity which was individually required.
What are the ages?
Age lordship in the memo.
Just tell us the ages we want to close.
In my case, lordship, 32 and 37 years.
Now we'll wait till January 27th. We'll decide how much to bring it, bring it down to.
Matters has been already been fixed, so lordship one.
29th,
Lordship.
29th, Thursday?
Lordship.
Huh?
Lordship.
We
Second-
we try to
second-
keep it in the same week. Because if we are here on a particular date, taking a particular bench, then week we are here. So if I can take this, I can take that. Otherwise it is,
Only one observation maybe.
because we do not want the other courts to be burdened because we are fixing updates. That becomes, yes?
Only one observation will be there, lordship. If hearing do not take place, then my IA will be considered because of that period they have already undergone.
This will be the third time your case is being listed, is it not?
Lordship,
We will ensure
lordship,
that it is heard.
lordship.
List this matter again on the 29th of January 2026. Since there is paucity of time today. Hoigul, you heard that word? Kane Kanmari? Thank you.